Good morning, Mr. Lo. Good morning, Mr. Bodlani. Good morning, Advocate Johnson.
Morning, Chair.
Thank
Morning,
you.
Chair. Good morning, Commissioners.
Thank you.
Morning, Chair, morning, Commissioners, and morning to Mr. Bodlani, and good morning, Advocate Johnson. Morning. Advocate Johnson, just to perhaps wrap up what we had touched on before we broke at 3 yesterday. You recall we were considering your Section 2813 authorization, and we considered the list of people, the 12 people. You could not yesterday recall, no, we confirmed that only the first 3 people in that Annexure A were referred to in the Section 27 affidavit by Mr. Adams. The issue was where the names of those itemized from number 4 to 12 were obtained from, because at that point, we agreed that no independent investigations had been undertaken by IDEC. You could not immediately recall. I just want to check whether overnight you were able to recall, or in engagement with anyone, you were reminded as to the source of those other names. Thanks.
Commissioners, as I didn't have an independent recollection yesterday, I did engage with Advocate Ramsamy, whom I said did submit the application. And I provide the response as I was given I had no recollection myself. And Advocate Ramsamy indicated last night that she had got the list of names from my office, wherein I had indicated that this list had been provided by Mr. Perumal after his having engaged with Mr. Adams. And that is the recollection she has and the recollection she provided to me. I cannot gainsay her recollection because I don't have
Your own.
an independent recollection. So
Indeed.
I'm not prepared to say that she is wrong, except that that's the recollection she has.
So if we accept what you say, and similarly, we too don't have a basis to gainsay it, before you authorized even a preliminary investigation, that suggests that Mr. Perumal was already engaging with Mr. Adams.
That is correct.
Was he doing so within his mandate in circumstances where IDEC itself had not even authorized an investigation, a preliminary investigation, let alone an investigation in terms of Section 28? How could he do that? And on what authority does he so do?
He would have to indicate why he engaged with Mr. Adams over and beyond the initial indication of provide a Section 27 affidavit.
Okay, now as the ID.
So I'm not sure if as part of that went further for purposes of clarification, but for purposes of the process, we had a Section 27. I've given it to the prosecutor, and the prosecutor then submits an application.
And at this juncture, as I understand things, Mr. Perumal is not aware of the Section 27. Recall yesterday, you said you received it, you considered it, and you referred it to Advocate Ramsamy. So none of, the day before yesterday, I had understood you to suggest that you engaged Mr. Sissoko on that affidavit. But yesterday, you clarified that no, you hadn't.
Correct.
So as at the time you referred it to Advocate Ramsamy, you were about the only person who was aware of that affidavit. How does Mr. Perumal become aware and go so far as to engage the complainant, Mr. Adams, to obtain further information. Technically, he has begun the investigation, unless he was informed by you.
Yesterday, I did indicate that he contacted Mr. Adams to indicate he must provide a Section 27. So he's aware of that process only, from my understanding. But what engagements he would have had with him in between that process, Commissioners, I'm unable to take further, except that he would have spoken to Mr. Adams, had him provide the Section 27. Accordingly, I received a document in an envelope. I perused the document, which is the Section 27, and I then handed that to Advocate Ramsamy for the legal process of submitting a Section 28 application.
Now, I invite you as the ID to comment on the conduct of Mr. Perumal. Do you have any comment to his conduct of initiating what would sound from what you state, his own investigation before you authorize an investigation to be undertaken by contacting the complainant and obtaining this list of names from him? Is that lawful?
In terms of the process we followed, and after he engaged with Mr. Adams, because I don't have the direct knowledge of why and if he engaged with Mr. Adams, I do rely on Advocate Ramsamy. There isn't a process for that action.
Please say that again.
I said there isn't a process that I can refer to, Commissioners, for why he would have engaged Mr. Adams.
No, I'm asking you about the legality of his conduct. You are the head of the institution. This is brought to your knowledge that a very senior member of IDEC has conducted himself in the fashion that you describe. And I want to find out from you whether you consider that to be legal, and if it is not, what your comment to it is. And this is before I get to my third question, is now that you've been informed, what steps are you going to take?
So nothing, I think procedurally, I get the legality thereof. Procedurally, investigators would engage witnesses or complainants. But in terms of counsel asking me to provide a specific rule or legislation, there isn't one. Having brought that, now having the answer from Advocate Ramsamy, we would have to address the conduct of Mr. Perumal. But it is conduct that we would have to escalate, as we do have the IDEC judge for an independent consideration of the legality and or not of his conduct.
You escalate before you consider, you are the head of the institution.
Yes.
So you won't consider the conduct, you won't deal with it, you'll immediately escalate.
No,
What
I'm
do
not
you
saying
plan
that I
to do?
won't. I have to consider the conduct. I have to get a response from him. If the response is outside of the framework and the legality, it must then be dealt with through the IDEC judge.
Okay, now please locate it within the framework of legality in circumstances where on your own testimony, you have not authorized an investigation.
There is no legality that I can point to, Commissioners.
And it's important because as we go through these matters, one gets a sense, and I may be wholly wrong, and I would need you to help me to change my mind. It would sound like everybody in IDEC is on a frolic of their own. And this is the start now with this particular investigation. And as we'll see going forward, that seems to permeate through the organization. Is my understanding correct or wholly wrong? And I do accept, I may have the wrong end of the stick.
They don't go on a frolic of their own.
Okay.
We do adhere to the processes and the prescripts. I'm not saying someone may not deviate. Investigators are out in the field. If there is a deviation and it comes to the fore, then we have to deal with it and understand why the deviation. But there isn't a frolic of their own. They have to adhere to the internal processes. And as I did indicate to commissioners yesterday, apart from the legislation, we have tried to operationalize things in a practical manner. But if they have worked outside of the accepted framework, which is common knowledge in IDEC, then I take the point that council makes.
Can I just express the point differently? That you don't have standard operating procedures. You don't have protocols. And I say this because from the first day that you testified, as you were reading your statement, the question kept coming up. Do you have anything that regulates this internally? And you kept saying, it's how we practice, it's what we do. So the comment comes from that context, that you seem to have these unwritten rules of how we do things, and which allow people, your people, to make it up as they go along. You know, if Mr. Perumal, Chief Perumal, wants to speak to Mr. Adams, there's no prescribed process that wait until we've made a decision. If what you say happened is in fact what happened, then you're telling us there's no prescribed process that he can be held to that says to him, until there is a decision that we are taking this matter on, you may not engage with a complainant or any potential witness, because this and this and this could go wrong, right? About it, we all have to wait until a decision is made. If you don't have that kind of operating procedure prescribed, you could never blame him for rushing off to go and hold his conversation, whatever the content of the conversation may be, including if he chooses to prompt witnesses, you know, give me names. Do you have names? Your affidavit doesn't have names. Give me names. And what are you saying about those names? There's nothing that you could say. You acted out of the boundaries of what is acceptable according to our prescripts. Is that not a fair comment to make?
I take your point. If you would allow me just to add something.
Yeah.
It's not that we work without process. There are processes that are mapped out in the majority of, you get to section 27, when you get to 27, what it is that we must, there's a few of the, not a few, there's quite a few of those processes, Commissioner Baloy, that have been made practical for operational purposes. The point that is important that you make is
when you say made practical, what do you mean? That everyone understands that's how we do it?
Process map.
Okay.
So they are process mapped.
Okay.
So there are those process maps. The point that you make that becomes important for a future consideration is, what are all the eventualities that we should prepare for if you take this example? And did we prepare for those eventualities? And I think that is an important point that Commissioner makes, and one that I have to agree is we didn't process map every eventuality. It therefore in itself becomes a flaw in the process, in step 1 to step 2. But if something happens in between, what are the do's and don'ts? And in that environment, it has been somewhat difficult to process map every single thing. But I do take your point.
Yes, I don't want you to misunderstand me, to be saying your processes must provide for every eventuality. That would be to put too high a demand and standard that are on you and may prove to be impractical. It's not anything close to that I'm suggesting. What I'm suggesting is, and maybe let me put it kind of differently. It is, I would expect that Chief Perumal and everybody in IDEC, not just you, everybody knows that before a decision is made to take on a case, we do not speak to witnesses. We do not speak to complainants. I would expect that.
Correct.
And if there is such a position, and then we are able to judge Chief Perumal's conduct, that you acted outside of a prescribed protocol in that you went and consulted with a complainant, a potential complainant, even before a decision was made to take on this case for investigation. I'm speaking to that we have to have a measure against which we measure and consider what you say Chief Perumal did, that he went and got a list of people who are not in the Section 27, before you made a decision to take the matter on. At the very least, it's a point of curiosity. Why would and how would he have gone and gotten these names if there was no decision yet at that point? And I would want to be able to say to him, you acted to him, not you, to him, Chief, you acted contrary to your operating procedures. Explain why in this case you did that. You understand the point I'm making?
I understand the point you are making, Commissioner Baloy.
Yes.
And I did say yesterday that or one of the days, sorry if I got my days mixed, but as has been the case, when a Section 27 is maybe lacking in some or other detail, I just want that clarification. I'm not taking it to Mr. Perumal, that we do engage with the referee for purposes of clarity and or more information. That is allowed. But in terms of you can't do it. There's no hard and fast rule that you can't do it. It's preferable you really don't do it, except for purposes of clarity, where the Section 27 may lack sufficiency of detail in terms of the requirements of is there reasonable suspicion made out, etc., etc. Those are the grounds on which I would.
Yes, I understand you explained that yesterday. I would expect that in that process of seeking clarifications, that's a formal process. It's recorded. It is a formal process. You may not at that point yet have decided to take on the case, but I would expect that there would be a record that Chief Perumal spoke to Mr. Adams on this day, and this is what was discussed between them. Otherwise, if you don't have that kind of formal record, then there's no accountability whatsoever. You have no idea what your people are doing. So I expect that there must be a formal process, and Chief Perumal should be able to say to us that I got an instruction I got this Section 27 from the ID on this date, right? And we determined, or I determined, that it requires particulars. I met with Mr. Adams on this day, right? And here's what I discussed with him. These are the questions I asked him, and this is where I got these names. I'm talking about that kind of process. It has to be in place. Otherwise, you are in an environment where people indeed get to do what they decide is appropriate without any guidance.
Yes, there should be a record in the person's diary.
Yes.
And or an information note compiled.
Yes.
Of what the engagement was. I
You
agree with you,
accept that?
Commissioner.
Okay, thank you.
Advocate Johnson, just for clarity, you said that your processes do not cover all eventualities. What I want to know is whether, with regard to the Fadil complaint, I'm very sorry, the Fadil Adams complaint or issue, there was anything out of the ordinary which would not have been covered by your processes?
Not that I can think of, Commissioner.
Thank you.
Sorry, Chair. I cannot. Yes, Chair. Sorry.
Thank you. Thank you.
Good morning, Advocate Johnson.
Good morning, Commissioner Khumalo.
The list of names, so what Advocate Zillo started with, I had understood you that you say the list of names came from Mr. Adams.
According to the prosecutor, yes.
Yes, and those names were not in the Section 27 referral, the affidavit.
That is correct, Commissioner.
Yes. Now, your Section 2813 authorization, we were in file 8 on 3282.
Sorry, the reference, Commissioner?
File 8,
Yes, I have file 8,
page 3282.
38
3282.
3282. I am there.
So
Commissioner.
I've moved past Mr. Perumal. We are now dealing with the ID's conduct. What you are saying in this authorization is that you have reason to believe that the offenses you've mentioned on page 1 have been committed or are being committed by the people listed in the annexure. And then you mentioned the 12 people. Now, what was the factual basis for your conclusion or your reason to believe that 8 of the 12 people there have committed the offenses listed on page 1 and they should be investigated? Because the only people who were mentioned in the affidavit, we know it was 3 or 4 people, and the offenses those 3 or 4 people had committed were mentioned in the Section 27 affidavit. Now, if all Mr. Adams gives Mr. Perumal is a list of names, and it's now 12 people, what is the factual basis for you coming to a conclusion as you do on 3283 that you have reason to believe that the persons in the annexure have committed the offenses you mentioned on page 1 of the same authorization?
Commissioner Khumalo, that would have been the application for the authorization. I did ask that that be sent, and Advocate Maga, I did send through to him. I think when we were about to conclude yesterday afternoon, it was yourself, Commissioner Khumalo, who reminded that this should have come from somewhere, and usually there's an application. And I indicated that the application is not with this document. And we did ask for that document, and the document has been procured. That shows an application. And in that application, these names are also mentioned.
But if the prosecutor has not engaged with Mr. Adams, and all you've given the prosecutor is the Section 27 affidavit, how can the prosecutor come to you and say, I have reason to believe that people whose names are not mentioned in the affidavit, whose conduct is not mentioned in the affidavit, have committed such serious offenses as you list in 1.1 to 1.11 on page 3282? Where would the prosecutor get that from? Because all you've given the prosecutor is the affidavit. And on what basis would you then form a view that the people whose names are unknown to you, there's no complaint in respect of these people, there's no affidavit suggesting that any of these people have done anything wrong? How do you arrive at a conclusion, or how do you form a view that they have committed such serious offenses and should be investigated?
I would just like to, if I can, have sight of the application. But I hear the point that you are making, Commissioner. I provided, she was provided with the names. She would have had to indicate then in the summation whether or not they are linked and how they are linked. And that is what, if we could just look at that, so that I do not, I took Commissioner Baloy's point yesterday afternoon.
But you see, my difficulty remains that all you give is My difficulty is this, that you give her the affidavit, we have seen the section 27 affidavit. It doesn't mention most of the people in the annexure. It does not say any of these people have committed offenses. You give her that affidavit, and then you say you gave her a list of names. That's all you gave her, without saying what those people did or what their involvement is. All you gave her was a list of names. What could she write back to you based only on the affidavit and the list of names? That would make you form a view that these people have committed such serious crimes that would justify an investigation against them.
The application would have had to link them to the offenses. And I would just like to see that part. But what I have to concede, Commissioner Khumalo, is in the absence of there being a link between what is said in the 27 and the list of names,
That should be the only link.
yeah, then they shouldn't be included.
They should not have been included in this annexure, because even you, as you got that application, you would say to her, but these people are not in the affidavit. No allegation is made against them. So where would you have got this link for you to include these people in the application that you give to me? Because the same affidavit you would have seen before it went to the prosecutor.
Would be the same.
So there's nothing the prosecutor could have told you that you did not already know based on the affidavit and based on the list which you gave to the prosecutor. So for you to form the view that these people have committed fraud, defeating the ends of justice, breach of these various statutes, there has to be a factual basis. It cannot just be made in the dark. And then IDEC uses its powers to attack, or to attack is a strong word, let me withdraw that, to target South African citizens without any factual basis and without any legal basis, and decide that it's going to conduct an investigation against them. I would understand if you said, Mr. Adams came back with a supplemented Section 27 affidavit, and in that affidavit, he made allegations against these people and told IDEC what conduct on their part constitutes an offense, because that would have been a basis for you to authorize an investigation against them. But in the absence of that, I cannot see how you could have authorized an investigation against many of these people listed in the annexure. Do you want to comment?
I can take the point no further.
But you
And
accept?
I accept the point, because the information came, when you look at the documentation, he's made statements, it is after that date. And commissioners are referring me to as at, and I can take it no further, Commissioner Khumalo.
Oh, just, sorry. One or two questions before the last question. I heard you say, if I could see something, did you mean there's something you would want to look at in order for you to respond meaningfully, or did I misunderstand you? I'm asking because if there is something you want to see, perhaps you should articulate that fully so that you are afforded an opportunity to see that.
Thank you, Chair. The document I wanted to see was the application that Advocate Ramsamy would have submitted towards this authorization. I just wanted to see if, in fact, in that document, she stipulates anything about the link. But we can do that in an
During-
adjournment.
yeah.
And I can come back to that point.
Yes,
But
yes.
I do take Commissioner Khumalo's point
Yes,
and agree that beyond that, I can take it no further. It is as it stands
Yes, yes.
at the time.
All right, when we resume, perhaps then after the tea adjournment, you should indicate if you want to revisit this point or this issue.
Thank you, Chair.
Thank you.
Can I say though, Advocate Johnson, that the linking of these names to any specific factual allegation would not be in the submission from the prosecutor. It would be in whatever submission was made to you by Chief Perumal. So the one that gives, by the time you give the list to the prosecutor, Ms. Ramsameh in this case, you already have been told these people are implicated. Otherwise, it would defy logic and how you reasoned this, that all you got was a list and then you didn't ask Chief Perumal. If this was done verbally, if this was done verbally, you did not, you had nothing in writing. If you don't have it in writing, in which case I would expect you to give us whatever submission Chief Perumal gave to you, which must explain why he's giving you these names. Who are these people? How are they implicated? And then you give that to the prosecutor to say, include this in your application. Or he told you verbally why these names must be included in that list, or why are they relevant? So it seems to me that the answer doesn't lie in the prosecutor's submission to you, unless you say to us, I did tell the prosecutor why these names, how are they implicated, and why they should be in that list. So you would be looking at the wrong document, it seems to me. And I'm not saying don't look at it. Maybe the answer does lie there. But in my thought process, whoever gave you the list must have said to you, this is how they are implicated, for you to be satisfied that indeed they should be included in this list. And you've heard what we say about the power that authorization you gave, what it imposes and the burden that it imposes on those people. So with that preface, did you discuss or ask Chief Perumal when he gave you this list, why these people, how are they implicated?
As I indicated this morning, Commissioner Baloy, I had no independent recollection. And so I don't want to venture a guess whether or not I even had a conversation, except that when the list was given to the prosecutor, there was no reason why she may not have, I'm not saying she did, why she may not have had an engagement with Mr. Perumal as they were part of that team. But that is mere speculation. And I do take the point that you make.
The difficulty I have with your answer is the question yesterday on this topic was, you were going to find out where did you get this list from? Yes. And logic dictates to me that once you were told by Ms. Ramsameh that you told her that you got it from Chief Perumal, that's who you would speak to. That's my expectation. And I know it's a fair and reasonable expectation that once you were reminded, because that's all that Ms. Ramsameh seems to have done for you, is to remind you that, no, you're wrong, it didn't come from me. I got it from you, and you told me you got it from Chief Perumal. You have to explain, why did you not ask Chief Perumal? Confirm I got this, because we know you've been talking to him. You've been asked as you were testifying some questions, and you've come back and said, I've spoken to Chief Perumal. On this question, the expectation, and I don't know why you wouldn't have done it, is once you were reminded, you would have called Chief Perumal and said, remind me, did I get this list from you? He says yes. Then you say, especially because I said to you, it appears like an abuse of power. And in the light of that, I would have expected you to say, why did you give it to me? Why did you say to me, these people are relevant? Can you just explain why you did not speak to him about this, so that you give us a complete answer? Because it's not helpful. In fact, it doesn't take the matter any further for you to say, I spoke to Ms. Ramsameh and she said, I told her it came from Chief Perumal. Well, we're exactly where we were yesterday.
Correct.
So why did you not speak to Chief Perumal, ask him, confirm you gave me the list? And then the next logical question, because of yesterday's discussion, would have been, where did you get these names from? How did you go about getting them? Why did we include them? Can you just explain why that did not happen?
I did speak to Mr. Perumal,
Okay,
and Mr. Perumal has no recollection
okay. That he gave you the list.
that he gave me the list. I said to him, I conveyed the message of the prosecutor, and he conveyed to me, he has no recollection of having given us or given me a list.
Okay. I guess let me leave it there for now. Thank you.
Thank you, commissioners. I would like us to consider, in relation to the issues under discussion now, the position you assumed before the ad hoc committee. And for that purpose, I would like to refer you to file 3. And in particular, if we could go to page 559. That is CJC 375, which starts at 523. That's a transcript of your testimony before the ad hoc committee.
Sorry, Council, you want me to go to page?
559. Now, let's start, it's not numbered, the lines, but you see the line that reads the committee adjourned for lunch.
That is correct.
I want to pick it up from there. Advocate Arendse says to you, we are dealing with a referral by Mr. Adams in terms of section 27. You said that apart from seeing him on television screen, you do not know him at all. You say that is correct. You did not receive the referral yourself when it was received by IDEC. That is correct. What is the date of that referral? The second week of November 2024. So before ad hoc, you suggested that you didn't receive the referral affidavit from Mr. Adams. The last 2 days before the commissioners here, you indicated that you received it and you actually triggered an internal process resulting in a section 2813 application for a preliminary investigation.
Correct.
The two are contradictory. Which is the true position? Is it what you stated to the ad hoc committee or what you are stating to this commission?
I took the question at the time to mean that I received it from Mr. Adams. That is why I prefaced it as I did by not knowing him. My office did receive the section 27. That is the position. I received a section 27 deposed to by Mr. Adams and dated the 21st of November, 2024.
But how could you so understand when Mr. Arendse's question is very direct? You did not receive the referral yourself when it was received by IDEC. That's the question.
I did receive the referral.
And your answer to the ad hoc committee is, that is correct, I did not receive it.
That's what I took it to mean, that I did not receive it from Mr. Adams, but I did receive the referral.
Where then did you receive it from?
The referral, when it came in an envelope to IDEC, to the officers, through the normal document receival process, and then it was submitted to my office.
Okay. So you received it from IDEC. That's what you wanted to clarify to Mr. Arendse. Didn't receive it directly from
From
Mr.
Mr.
Adams by hand, you received it from IDEC.
Correct.
Okay, your engagement doesn't go that far. But let's move on. Yes,
Are you leaving that page?
I am not, I'm staying with
Yes,
the page.
no, let me leave you to do
All right.
it.
Now, the second leg of your engagement with Mr. Arendse on this issue, towards the bottom of that page, Mr. Arendse says, you are not aware of Mr. Adams also referring this matter to the National Commissioner of Police, the National Commissioner or the Minister. You say, no, not at all. Do you see where I'm reading?
Yes.
But we know after engagement yesterday that MK16 tells us otherwise. Your entire basis for being persuaded by the referral is precisely because you said these issues had been raised with the minister. The minister or the minister's office had purported to refer this matter to you in terms of Section 27. We had quite a lengthy engagement, and you too, with the commissioners about what was the complaint to the minister. We suggested that it related to interference and interception. You insisted that it related to what is contained in the Section 27. Going with your understanding, then it can be correct that you did not know that he had complained to the minister, because we know our annexure MK16, which you confirmed you received, and you responded to, although you don't quite recall in what terms, tells us otherwise.
That is correct. At the time, I did not recall receiving anything from the office of the minister.
So why didn't you say, no, when did you say, I don't recall? You definitively say, no, not at all.
Not at all. Correct.
So what was ad hoc to believe? What if ad hoc believed that statement? You intended for ad hoc to rely on that statement.
That is correct. I did not recall remembering, that's stupid English. I did not recall receiving that from the office of the minister.
Yes, Commissioner.
You see, Advocate Johnson, your testimony yesterday was that IDEC received the minister's letter, and the
Correct.
minister's letter was unhelpful. And you instructed Perumal to get an affidavit from Adams. Now, that's completely different to what you said to the ad hoc, because the impression you are creating here is that it is Adams who came to IDEC, and this thing landed on IDEC's desk, when in fact yesterday we agreed that based on the minister's letter, or rather the letter from the minister's office, it is IDEC that reached out to Mr. Adams. So which is which now? Because here, it's Mr. Adams who's coming to IDEC, but yesterday you were quite clear that it's the minister who came to IDEC. The letter from the minister was not helpful. You then instructed Perumal to reach out to Adams, and that's how the Section 27 affidavit came about.
That is the correct position, Commissioner Khumalo. When I say that Mr. Adams came to IDEC, it is Mr. Adams who wanted IDEC to deal with his matter. But the position, as I indicated yesterday, is the position of having first received a letter from the minister. I did indicate that there were no attachments. I therefore asked Mr. Perumal to please engage Mr. Adams, as Mr. Adams wanted IDEC to deal with his matter.
So, and then the last engagement on that page, your response to the ad hoc gives the impression that Mr. Adams's referral landed on your desk in the middle of December 2024. Now that cannot be correct, because on the 6th of December, you gave the authorization, the Section 28 sub 13 authorization. So it cannot be correct that the referral landed on your desk in the middle of December 2024. Because that is the question. Advocate Arendse says, after the referral in November, when did the matter land on your desk, and what work would have been done on it? So the question, although it's 3 questions in one, it is specific. When did the matter land on your desk? And your response is, at the time I received it, it would have been the middle of December 2024. That was incorrect, what you told the
This
ad hoc
is
committee.
incorrect, yes.
Because already by the 6th of December, you had had engagement not just with Perumal, but also with the prosecutor.
That is correct.
Because you would have, by the 6th of December already, looked at the application from the prosecutor and formed a view that you are going to authorize investigation into those 12 people that we mentioned earlier.
That is correct, Commissioner Khumalo.
Thank you.
But the question is, why did you say to the ad hoc committee that you received the section 27 in the middle of December. Why would you say that?
At the time, Commissioner Baloy, that was my recollection. In coming to,
Yeah, carry on, sorry.
sorry. In coming to this commission, I had to offer myself properly with all of the facts. I'm not saying that the ad hoc was not important. I didn't go through all of this detail with my team when I went to ad hoc.
But you would have prepared to go to ad hoc. I mean,
Yeah.
I suspect they will be deeply offended if they are to understand you to mean you went to that committee without preparing and looking at your records on this matter. So I must assume that you prepared when you went there. You knew what the issues were. There are terms of reference as in the question that they are required to deal with are not very different from what we are dealing with here. So you knew that the referral and your investigation and your arrest of General Kumalowe and what General Mkwanazi said on the 6th of July were at the heart of what they are investigating. So I cannot conceive of a situation where you did not go into your records of how this started. This are what culminates in prosecution. Where did it start? I can't, it's difficult to accept you saying, I did not remember, when in fact a lot happened before the 6th of December. A lot, you activated things. You received a section 2813 application. You authorized things to be done before the 6th of December. How can you make a mistake? How could you genuinely make a mistake that you received this referral middle of December? It's improbable that's what happened. It's improbable that you did not remember that you received this in November already, before the middle of December. In fact, here you say middle of December. We know it's much earlier that you are actioning and making demand and signing those documents for people to be investigated. It's improbable that you didn't remember it. You can comment if you have any comment, but that's my view. It's just unbelievable that you did not remember when you answered the question.
I take your point, Commissioner.
Thank you.
Thank you, commissioners. And staying with your testimony before the ad hoc committee, can we go to page 557? And just to introduce the issue, it starts at 557, bottom thereof. Advocate Arendt's stating, you mentioned that you do not know, have never met Mr. Adams. You mentioned in your statement that when he approached IDEC, he had already gone twice to the subs in Western Cape and Gauteng province to open cases. Now we know that he didn't approach IDEC. IDEC approached him. We know that now for a fact. Do you confirm?
Correct.
And then Advocate Arendse continues, and then you say somewhat miraculously, these cases disappeared. Now, do you have first-hand knowledge of this, or are you just conveying information that came to your knowledge at some point? Your response at 558 reads thus: this came to my knowledge through my own investigators who had taken the Section 27 referral affidavit from Mr. Adams. Part of what he indicates is that when he received information which he alleges was pushed under his door, which is part of the affidavit.
He says he received documents under his door.
Also, which is part of the affidavit is the allegation that.
Is the allegation.
But did you receive those were those documents disclosed to IDEC?
They were not part of the 27, and I'm not aware that any of those documents were disclosed to IDEC.
So you never received, you're not aware of receipt? No. Let's stay at page 558. At the bottom, Mr. Skosana says, did Mr. Adams bring up a classified document in this report? If so, are you authorized to investigate classified intelligence, and which specific section allows you to do so? According to the law, only the Inspector General of the Intelligence Office has the authority to investigate such matters. Your response is overleaf at the top of 559, wherein you state, what the ID herself received was a Section 28 application based on Section 27 referral. I'll pause there. When you say what the ID herself, you are the ID.
Correct.
Oh, so you are speaking of yourself in the third person. I shouldn't get confused. Okay. You continue. The investigators got an affidavit from Mr. Adams. Let us just say the ID was given a document purported to be classified. The ID is in possession of top secret clearance that therefore will allow me to look at those documents. However, before we do that, even with the state security agency matters, to err on the side of caution would indicate to the person giving us a document, can you rather declassify before you give it to us? But I did not have sight of any of the classified documents. Now, you say you received a Section 28 application based on the 27, and you say, let us say the ID was given a document purported to be classified. Are you suggesting that you were given a document that was purported to be classified, or are you saying it's a hypothetical example? Should you be given a document purporting to be classified?
It was a hypothetical
Okay.
example.
So you have not seen the content of the documents that were pushed under Mr. Adams' door?
Correct, I have not.
You remember yesterday, you relied on specifically those documents as a ground for the suspicion that Mr. Adams harbored. How could you when you haven't seen the actual documents?
I rely on what he says in his affidavit, that this is, I received information under my door, this is what the information said. So I relied on his affidavit. There were no, he didn't give us classified documents, or I didn't get any classified documents. So, Counsel, he refers to it. He says, documents having been pushed out under my door, I relied on that information. And of course, I think he goes on further to say he relied on other information he would have got.
Now, if you are looking for the referral affidavit, Mr. Adams's, it's at file 2, page 512, and the paragraph you're referring to is paragraph 3. File 2, page 512.
Yes, that is
Now, if we go to 513 at paragraph 3, he says, my suspicion about General Khumalo and others became more clearer when I found an envelope pushed under my office door at Parliament, which contained some crime intelligence procurement documents using secret funds of crime intelligence and vetting documents. So, if I understand you correctly, within the engagement yesterday that there were no grounds, you said that is one of the grounds. Now, you haven't seen the content of the envelope and the documents therein, but you rely on Mr. Adams, who says, trust me, I've read them.
That is correct.
Okay. Yes,
Can I, just on this, follow up on this? I don't remember which provision exactly in the NPA Act, but there is a provision that provides, that states that if in the course of your investigation, you come upon, I'm going to call it information because I don't remember the exact terminology of a possible offense, another offense that is not what you're investigating, you can refer it on if it's not part of what you're investigating. Am I correct in remembering such a provision?
that is correct.
Yes. Now, on this here, in the referral affidavit, Mr. Adams tells you that I have intelligence documents that were shoved under my door. And from those documents, I have even more reason to believe that Khumalo and them, General Khumalo and them, have committed offenses. Isn't that typically, because you know, you are in the sector, you know that when he says somebody shoved intelligence documents under me, it's material that you shouldn't have. You know that.
Correct.
Did you do anything in accordance with the provision of your act that says if you come upon information that suggests a possible offense being committed, you refer it to another agency? Did you refer this possession of intelligence documents that were on Mr. Adams's own account were not properly given to him or lawfully given to him? Did you refer it to the appropriate agency for investigation?
I did not, Commissioner, not having any knowledge or sight of the documents he referred to.
He tells you that he's got documents that speaks to intelligence matters. It's crime intelligence documents about procurement and something else. You have acted on his intelligence documents that someone gave to me, and I don't know who they put them under my door. That seems to me a classical case of you should have referred this to somebody. You don't need to see the documents to know. He's telling you I've got possession of those documents. Why did you not consider it a case that must be referred to somebody else to look at, the appropriate authority to look at?
I did not.
Okay. And you don't have a reason why you didn't do it?
No, ma'am.
Okay, thank you.
Thank you, Commissioners. Your October 25 statement to the Commission, regarding the dockets. Now, this is, as of the 6th of December, you have authorized.
Ms. Selo, sorry, can I
Yes.
please interrupt you? I didn't realize
Absolutely,
you're asking a
absolutely,
different
Commissioner.
question. Advocate Johnson, that referral that Ms. Selo referred you to exchange with Advocate Arendse, where you say you were not aware that a complaint has been laid with the minister. Can I ask you to repeat your explanation for why you answered the way you did?
At the time, I did not remember that letter. At the time when I was at the ad hoc committee.
You did not re-
That I did not recall that we had got a letter from the office of the minister.
Okay, so it's the same explanation.
It's the same explanation.
Thank you. Thanks, Ms. Selo.
Okay, that clarification. Staying with the transcript. And page 562. At the top of 562, Advocate Arendse says, were you aware that the matter had also been referred to SAPS? You respond, only insofar as Mr. Adams in his affidavit indicated his initial report to a police station somewhere in the Western Cape. And then he's reporting of the same to a police station in Gauteng. That is the only SAPS reference that IDEC is aware of. Then Advocate Arendse refers you to page 2H3 of the ad hoc record and states you will see there that is an email from Chief of Staff Ngabinde dated 1st November. Good morning, Major General Sibula. Ministry has received this complaint from a member of parliament. In order for the ministry to respond accordingly, please furnish this office with a report in responding to this complaint and the details of the investigating officer who was assigned to investigate those cases. Your report is expected by the 4th, Monday, 4th of November. You are not aware that this complaint was also being laid with the minister at the time, Minister Mkunu, and in turn he was referring to the police, and you say, no, not at all. Mr. Arendse continues, at the front of your bundle, there should be an information note that is addressed to the National Commissioner. It is dated 30th July 2025. It is signed by Lieutenant General Divisional Commissioner Inspectorate, P.A. Jacobs. This memo records the passage of this complaint by Honorable Adams and how it gets to the National Commissioner. The purpose of the information note is to provide a response to the allegation that, one, the division inspectorate was complicit and irregular in the handling of the service complaint leveled by Mr. Adams, And two, to reflect on an averment that the division inspectorate irregularly handed 7 dockets to the investigating directorate against corruption, IDEC, were those the dockets that would have been requested by the IDEC investigation. Then you say the dockets that were requested are those dockets. So you confirm. I'll stop there. Yesterday, we gave you 2 annexures MK15 and MK16. And they should be a separate, yes. Now, if you go to MK15, it starts at page 269.
I have it.
At page 270 is a cover page of a document, an urgent memo from Lieutenant General P.A. Jacobs. It's dated the 30th of July, 2025. We, before this commission, have it as MK15. Now, it would appear that it served before, the same pack of documents served before the ad hoc committee. And that is the report of General Jacobs. Now, if you go to page 272, and I take it that the same report with all its annexures served before the ad hoc committee as we have it here. At page 272, it lists all the annexures. Now, if one has regard to the content of this report, then it was brought to your attention, at least at the ad hoc committee, about the complaint to the minister's office, it being referred to the national commissioner, and so on. Why then, when reference was made to this particular document, you do not say, oh, now I learn that, I'm only learning now that this happened?
I do believe I indicated to the ad hoc that
Yeah.
at the ad hoc, this was the first time I saw this report of General Jacobs. It had not been made available to IDEC before. If my memory serves me, I do recall that that was my response, Council.
Okay, now, let's, because we are on this document, unfortunately, I have to leave it for the moment and to come back to it, because I would like to go, I referred you to your statement, paragraph 8, and you don't have to go there if you can trust me to read it correctly into the record. At paragraph,
Can you display it so that at least she
yes,
has sight
that we
of-
can do. At paragraph 23 of your statement, page 7, it reads, the referral was made by Mr. Fadil Adams. It was not treated any differently. It was supervised and overseen like any other. There were 4 dockets that were relevant to the referral. Following the common established process, I sent a letter to SAPS Divisional Commissioner Detectives Lieutenant General Sintumule requesting the dockets. That's what you state. You repeated that same allegation or the claim before ad hoc at page 562, having dealt with General Jacobs' report. At 562 at the bottom, you state about the dockets. They were requested by myself as the ID on a letter to the Divisional Commissioner Detectives General Sintumone, given that as the Divisional Commissioner Detectives, I automatically and ordinarily assumed that any dockets to be found, or if they were at head office, would have been with the detective component. You are asked by Advocate Arendse, when would that have been? You received the complaint early in November. Your response is, I will, when we do break, ask my office for a copy of the letter, but it will have been soon after the authorization of the matter. So it's no earlier than the 6th of December. We've established a date to it now.
That is correct.
Okay. You say, but I do recall having written to Lieutenant General Sintumule, and I recall her then ensuring that the dockets were received accordingly by IDEC. Up until yesterday, your testimony was that you requested these documents from Major General Kumalo, and you clarified not Dumisani Kumalo. I think you provided another name. Mbuso, thank you, Commissioner. Mbuso Kumalo. Please explain. You say from General Sintumule, you say to Major General Mbuso. Who did you request these dockets from?
So at the time, Commissioners, my recollection was my letter to General Sintumule. Sorry, Chair. At the time, my recollection was my letter to General Sintumule. I had subsequently, but well after ad hoc, the investigation team advised and in fact showed that we had first written that morning to General Kumalo of Gauteng, the detective head. And on the same day, a letter followed to Lieutenant General Sintumule as the Divisional Commissioner of Detectives.
Why to both?
When the letter was written to General Kumalo, it was because Adams had indicated he had opened dockets in Orlando, Chair, that falls under Gauteng. So we had to write to the commissioner. And he indicated, if my memory serves me correctly, he indicated to the investigator, either it's Mr. Rapes or Mr. Perumal, that the dockets were no longer with him and that the dockets were with the inspectorate, if I recall the feedback correctly. That would be the inspectorate that we're referring to in terms of where General Jacobs was the head. I then write to the Divisional Commissioner of Detectives, Lieutenant General Sintumule, as the national custodian of the dockets. And General Sintumule facilitated the receipt of those dockets. Those dockets were then, in fact, commissioners and council found to be with Lieutenant General Peter Jacobs and were then handed over.
So Mr. Adams would have told you on the 6th itself, because you wrote to General Mbuso Kumalo on the 6th. But on the same day, you write to General Sintumule for the explanation that you've just given. It must mean, therefore, that after writing to General Kumalo, even before he responded to you, you were in touch with Mr. Adams about these dockets, and then he told you then that actually they are with the inspectorate. Is that how it happened?
No, Commissioner Baloy. In his affidavit, the Section 27 referral, he initially in paragraph 1 refers to the dockets he opened in the Western Cape. And thereafter in paragraph 8, he says, a few days after I opened the 3 cases at the Cape Town police station, I decided to go to Gauteng. And I went to Orlando police station where I opened another 3 cases based on the 3 cases I had opened in, and that is where we got it from, that he had opened cases again in Gauteng.
I understand that. You, and unless I misunderstood you, I understood you to say to Ms. Sello that you wrote to General Kumalo requesting the dockets after you, because you're relying on the Section 27.
That is correct.
So you write to the Gauteng head, General Kumalo, to give you these dockets. This is on the 6th of December.
Correct.
Yes. But on the very same day, you write to General Sintumule now at head office, even before you get a response from General Kumalo. And I understood you to say you wrote to General Sintumule because Mr. Adams told you that the dockets are with the inspectorate. Did I understand your evidence correctly? Or did I hear it correctly?
Commissioner, we wrote to the provincial head, Major General Kumalo. he had informed the investigators that the dockets were not with him. It is on that basis that we then made the follow-up on where the dockets were. Now, I'm not sure whether it was Investigator Rapeso or Investigator Perumal who subsequently found out that those dockets were with the inspectorate, which is why we then wrote on the very same day. But they had got a response that it is not with Major General Khumalo.
Okay, all right. And that response, they didn't get it from Mr. Adams. I
No.
had misheard you then.
You must have me.
Okay, thank you.
Thank you on that. So you wrote to Major General Khumalo on the 6th, requesting the docket on the 6th. Major General Khumalo advised that the dockets are not with him.
He had an engagement with one of the two investigators. It's either Mr. Rapeso or Mr. Perumal.
Oh, so pursuant to your letter, he then had an engagement.
Correct.
Who initiated that engagement? It has to be one of them because we wouldn't know.
It would have been, it would have been Mr. Perumal
Okay.
that you spoke to. But
So-
the finding out, sorry, Council.
Go ahead, my
But the
apologies.
finding out of that the dockets were then with the inspectorate is something that was conveyed by Mr. Rapeso, the other investigator.
Oh, so I hope your council and representatives are going to keep a running list. Could you avail us that letter that you wrote to General Khumalo? And any written response that you may have received there too?
Yes, I can make that letter
Please,
available.
would appreciate it. Then you write to General Sentumule.
Correct, Council.
Same day, I take it, the 6th.
Yes,
So can I include that letter in the pack, in the request for documents?
in fact, when we take the tea adjournment, I do believe I have them with me.
Okay.
If I haven't made any notes on them, I will make them available. If I've made notes, apologies, and we'll make sure we get you clean copies. I will avail what I have.
Accepted.
If
Thank you
there's
so much.
anything short, we'll ask for that to be availed to yourselves.
And then, so you wrote to Major General Khumalo because of the Orlando dockets.
That is correct.
Who is he?
Particular, because as per Adams himself, he says, I opened the very same. So if it's the very same, we get the dockets that we got. We didn't go back to we didn't see the need to go back to the Western Cape because he said he opened the same. He made the same allegations, sorry, Council, in Gauteng.
Can I just get clarity on this? When IDEC was told that the dockets are with the inspectorate, did it not cross IDEC's mind that, well, if the inspectorate is already investigating these issues, then it's their mandate. We don't have to deal with this.
I would agree with you, Commissioner Khumalo, if we knew what the dockets were doing at the inspectorate. It is for that reason that I write to General Sentumule, who is the custodian of dockets. She facilitates that process. If in fact she came back to IDEC to say that we cannot facilitate those dockets from the inspectorate because there is whether it's a service delivery complaint or whatever it is that they were looking at, then we had no right to ask for those dockets.
It's slightly different. You know what the inspectorate does, so you know what their function is. And you get told that the very 4 dockets you are looking for are with the inspectorate. The first thing that would cross my mind is it means they're investigating the same thing that I'm being asked to investigate. Because inspectorate is not the local police station, or it's not the, what do they call it, the station of first. I can't remember the term that was used many times. That's not where the case is opened. So if a docket is with the inspectorate, it must be there for one reason and one reason only, to investigate what went wrong with those dockets. So as part of your thinking process, either under section 27 or 28, did it not cross your mind that, well, if the matter has been referred to the inspectorate, they have authority to investigate these issues, then we don't have to duplicate or use the same resources that they are using for that investigation?
may I respond? That if the, and that is why I just go back to my previous point. If in fact, General Sentumula came back to indicate that the inspectorate was vested with the investigation and what that investigation was, and sorry, IDEC, goodbye, you cannot get those, we would have stepped back. The inspectorate, from how I understand it, Commissioner Kumalo, and if I'm incorrect, my understanding is they were looking at a service delivery complaint. That is how I see the inspectorate, is if the rest of the police are not doing what they're supposed to be doing. It does not, of necessity, therefore, equate that they would have been looking at the allegations that Adams made in his Section 27 referral, hence the request for the docket.
You said if I'm corrected, but I assume now having seen the June 2025 report, you know that.
I now understand it
You
differently.
now understand. Yes.
Correct.
On this, can I ask this question? When Mr. Adams gives you an affidavit, the Section 27, and he says, I've laid these complaints and nothing is happening, or they've been intercepted. Before you make the decision to investigate, is there a reason you don't inquire with the SAPS? They are your sister agency. You, at that point, I assume you know nothing. We have this inadequate Section 27 by any interpretation, by any account, it's woefully inadequate. It contains only suspicions. But more importantly, that affidavit tells you, I have laid a complaint with the SAPS about these matters. Here are the docket numbers. How is it that your first step as a sister organization, you don't say to the SAPS, we've received this complaint, this affidavit, what is happening? Because then you will get an answer that we are investigating, we are trying to get hold of whatever's contained in that report. You would have gotten that answer and you would have known to leave it, as you say, that had we known what's happening, we would have left it at that point. How is it that that's not the first thing you do? Instead of deploying resources, and I deliberately say deploying resources because you do have a complaint that you don't have adequate resources to investigate all matters that fall within your mandate that you should investigate. How is it not the first reaction to find out where the complaint has been laid before you demand the dockets, to find out, have you received this complaint? Is anything happening? Is there anything to this concern that they've been intercepted?
My first port of call, Commissioner Baloy, was I did call. I called Lieutenant General Sentumule.
After
Before the
you
letter.
received, before?
Before I sent a letter.
Yeah, but this is after you've now made the decision to investigate. So my question is, before you make the decision to investigate, before you say to Mr. Perumal, whatever you say to him that makes him go and speak to Mr. Khan, before you say to Ms. Ramsamay, make an application in terms of Section 28.3, include these names, before all of that, you haven't yet made the decision we are investigating. You get a complaint from, yes, a member of parliament, but he's a member of the public. For all intents and purposes, that complaint is not laid by a member of parliament because he's not representing parliament. He's a member of public who lays a complaint with you that, and the complaint, as we discussed yesterday, is my dockets have been intercepted. There's no intention to conduct any investigation. So I'm still at that point where that is the complaint. How is it that it is not the first step that you take to inquire from the SAPS? Is it so that you have these dockets? What are you doing about them before you make the decision? SAPS is doing nothing about it. Give us the dockets. We are now going to investigate this.
So it is on that basis, Commissioner Baloy, that we wrote to that we wrote to General Kumalo to find out if they had the dockets. When he said they don't have the dockets, my next port of call was a telephone call to Lieutenant General Sentumule to indicate, General, we have this matter for an investigation. We are looking for the dockets. We are given to understand that they are not with Gauteng. And one of my investigators has indicated that he has since learned that the dockets are with the inspectorate. General Sentumule indicated, and this was a telephone conversation, Commissioner Baloy, she indicated that she was not aware herself that the dockets were with the inspectorate. She would find out and she would come back. When she later came back, she had facilitated then the dockets to IDAC. And I don't want to sound like a broken record, Commissioner Baloy, but I repeat that had she at that stage said, I am sorry, ID, these are with the inspectorate for a very specific purpose, based on the points that Commissioner Kumalo has made, IDAC would not have asked for those dockets.
Maybe the problem lies with me. Maybe I'm not articulate enough. I don't understand why you don't understand my question. My question is, before you get to the point where you are now demanding or asking for the dockets, because now you're in investigation mode, so you're taking the dockets from the SAP. So we don't get to, General Sentumule could have said to you, sorry, I can't give them to you. You don't arrive there yet on my question.
Okay.
My question is, when you get the section 27, so you receive it in November, right? We've established that, not in December. You received it in November. My question is, when you receive the section 27, which tells you, I have laid a complaint, and now we know you had also received a letter from the minister's office. So in November already, you know that Mr. Adams has laid complaints with the SAPS in November. At that point, you haven't yet made a decision to investigate. You received this affidavit. My question is at that point.
Okay.
Let's assume you received it on the 21st of November as date of that affidavit, and you start actioning it on the 22nd of November. So we are on the 27th of November. My question is, on the 22nd of November, why is it that your first step is arising from this affidavit is to call whether General Kumalo, whether General Patekile, whether General Sentumule, to say there is a complaint that has been laid with the SAPS and the dockets have gone missing according to the complainant. Are you aware of this complaint and are you acting on it? Why is it that's not what you do first? In fact, what you do is you go into full investigation mode, and the next thing you do, you're demanding or you're taking the dockets. So I'm not yet there. I'm talking about your first move on these.
It would have been, at the time, would have been based on the fact that Mr. Adams makes the submission that he knows that his dockets would not be dealt with, and or the cases would disappear. And I do take your point that the section 27, as the commissioners now see it, is inadequate. At the time we base our actions on what was on the section 27. And on the 27, there are allegations being made against the police in terms of criminal allegations, as well as allegations that the dockets would disappear as they did in Cape Town. And it is on that basis that I make that call, Commissioner Baloy.
So you unquestioningly just accepted his say-so. He says to you in the affidavit, my dockets have disappeared, they've been intercepted, and you go into investigation mode. You don't question. Why would he say that? Let me verify that indeed nothing is being done about them. You say it's on the basis of what he says. So whatever he says, you just acted on that because that's what it is. He said so, and you went into investigation mode on that basis.
That is correct, Commissioner.
All right, thank you.
Thank you, Commissioner. Please help me here if you can, Advocate. At some point on the 6th of December, you are aware that the dockets referred to in the complaint are with the inspectorate, correct?
Correct.
I assume that you are aware of the function or what the function was of the inspectorate, that it plays a specific role, and that perhaps, in general, it's empowered to investigate service complaints against SAPS members.
Correct.
So it's acting in terms of law to have those dockets and to investigate, as you have now subsequently found they were doing, regarding the service complaints.
Correct.
Okay. Now, can you then point me to the legislation or any prescript that then gives IDEC the authority to dispossess the inspectorate of those dockets while that investigation is ongoing? What gave IDEC authority to demand those dockets?
IDEC didn't intend to dispossess the inspectorate of those dockets. What IDEC did is, acting upon the Section 27 and the subsequent authorization, IDEC sought to determine where those dockets were.
Yes.
And again, I repeat that if, in fact, those dockets could not be made available to IDEC, then that would have ceased that matter. Because for me, Council, my interpretation is the inspectorate is dealing with a service delivery complaint. IDEC has allegations of criminality together with the allegations by Adams that my dockets will disappear, etc. It is on that basis that we approached the police. I can take it no further than if we were told that the inspectorate cannot release those dockets, then that is where it would have had to end. We have no authority, and we were merely making a request.
Yes.
Which request did not have to be acceded to, Council. The request could easily have been denied for access to those dockets.
Now, we know that you addressed a letter to...
Sorry, but you're conducting an investigation, so you could have demanded to them. You do have the legal means to, in the course of an investigation, to demand access to documents, no?
Correct. If we had to, we would have had to subpoena them through the National Commissioner. And that, unfortunately, is not the way to do the business. And what we could have done, had we not been given access to those original dockets, would have been to request copies of the dockets so that we could then look into those allegations.
Yes. No, I was just clarifying, just in case the impression you leave us with is that, well, SAPS could have refused with these dockets, and that would have been the end of it. I'm just trying to make sure that's not what you're seeking to convey. Right, thank you.
Correct. We could have requested copies. That has been practiced not just in IDEC over the years, and the police are amenable to giving you copies of the dockets.
I'm making a different point. The point I'm making is, in the course of investigation, you do have the power, the legal power, to obtain documents, and that would have included these dockets if SAPS had said to you, if General Sintumile had said to you, sorry, you're not getting them.
That is
because you're in full mode of investigation, you did have the power and the means to get them legally.
correct.
Thank you.
And now you get some time in the course of the 6th of December, you become aware there with the inspectorate. Earlier you said your first letter was to General Kumalo. Second letter was to General Sintumole. Now you know they're with the inspectorate. And the Lieutenant General Jacobs does not even have a courtesy of your letter requesting the documents. You know where they are now. But instead, one of your investigators is off to the inspectorate to go demand these documents, these dockets, or to, no, demand perhaps is too strong a word, to obtain these documents. Why couldn't you have addressed a letter to Lieutenant General Jacobs requesting copies, accepting that he has those dockets because he too is discharging a particular statutory duty? Because all you ever wanted were the content of the docket. My logic dictates that you would have asked him, can I have copies of these dockets? I understand that they are with you, the inspectorate, who is looking into a service delivery complaint. Why couldn't you do that?
I worked through the channel that we do when we request dockets, which would have been the Divisional Commissioner Detectives. However, I need to go through MK15. I do recall that there were people in the office of General Jacobs who indicated that the letters both to Generals Kumalo and Sentumule had been shown to the office of General Jacobs in order to indicate that a request had been made for those dockets.
Okay.
And
well-
that he then had an engagement, sorry, Council.
No, sir, we'll look
and
at
that
that during tea, it's fine.
Okay.
Those documents. My question was slightly different. You, as the head of one institution, you now have located the documents you require for your investigation. I would have thought it's appropriate that you once again, at that level, address yourself to the head of that institution to say it has now come to our knowledge this, may you kindly provide copies. I just point out that you failed to do so, I don't understand why.
I take your point. I reiterate, I worked through the channels we do in obtaining dockets, which would be the Divisional Commissioner of Detectives.
So now we know that on the 6th of October, IDEC, you received the dockets.
We requested them on the 6th of December.
Yes.
They were received on the 9th of December,
9th
the
of
6th having been a Friday, Commissioners.
Oh, thank
And
you.
they were put together and given to us on the 9th.
9th of December. Are you able to recall what light they shed on, remember, we still have that highly deficient Section 27 referral. Are you able to recall what light they shed on that referral?
The dockets.
Yes.
The dockets, when they were received by Investigator Rapeso.
Yes.
Investigator Rapeso then shared those dockets with Advocate Ramsamy, who already had the 27. And she appraised those dockets together with the Section 27.
So,
I did not peruse the dockets, Commissioners.
so you don't know whether they added any value to the Section 27?
I'm not aware.
Okay,
At that
you-
time, if they added value, except maybe this, if I could give this last response, I can see that we should go into an adjournment, is what did happen later on in January is that Mr. Rapeso, Advocate Ramsamy, and Mr. Perumal, after having gone through those dockets together with the Section 27, then had further engagements with Mr. Adams in order to amplify or supplement the statements that were in the docket, which I guess by interpretation means they were not up to standard or sufficient.
Were those, I assume those were what, A1 statements in each one of the dockets.
Correct.
On your understanding, were they any better than the Section 27 referral affidavit?
Of my personal knowledge, I cannot say, but from feedback from the prosecutors and the investigators, they were not substantial. And it was for that reason that there was that January engagement.
Resulting in the
In
supplement?
further supplementary affidavits for each of the matters.
Thank you.
Before we break for tea, Chair, may I close this little topic? And in fact, if you go to MK15 at page 295, that is part of a document from Legal Services subs legal services. Starts at 293. I'm particularly interested in 295, paragraph 4. And you say you never became appraised of the contents of the dockets. So at paragraph 4, the author of that document, Lieutenant General Kamani, states, only the complainant's A1 statements are contained in the 6 dockets. No other evidence is contained in the dockets. The lack of location information makes it impossible to determine proper jurisdiction at this stage. Let's jump ahead to 296. At paragraph 13, the current information contained in the docket is scanty and too vague to formulate charges against any suspects. As a result, legal services is unable to confirm that the required elements of any offense are contained in the dockets. In light of your admission that you never saw the contents of the dockets, you can't take issue with these findings.
I cannot,
Have to accept them.
I cannot take issue with these findings. Safe to say, when he makes these findings, he didn't have a section 27.
Now, I assume it's a he. His analysis of the contents of the docket, that's all I'm interested in. So as far as this is concerned.
I can't take issue with his analysis, Chair.
But based on the engagement we had yesterday, the section 27 referral affidavit could not possibly have made any difference, even if the writer of this legal report had sight of it. It would not have made any difference. I say that because when I engaged you yesterday, you accepted that there was nothing there. Do you accept that?
I accept the point.
Thank you.
Thank you, Chair. Might this be an opportune time for a tea adjournment?
Let's resume at 11:40. Let's adjourn.
Thank you, Chair.
Yes, Ms.
Thank you, Commissioner Chair.
What do we put away? We still have the transcript, we have file 3, we have many files. What do we put away?
Let's put away file 3, not too far. Please don't put it very far. And file 1.
So we need
Exhibit
3
file
and
1,
1 for
3
now.
and 1 for now,
Okay.
yes. And I think the transcript is in 3 as well, so.
And the MK, what do we do with the MK? Do we?
Oh,
keep
no,
it?
no, no, we keep the MK. Thank you, Commissioner Kumalo. You recall, Advocate Johnson, when we started yesterday, we started with the requirements of Section 27 of the NPA Act, the referral affidavit.
Correct.
And you indicated to the commissioners that where the affidavit is deficient, it is standard practice that you engage the person who made the referral to get clarity. Is it safe to assume that you do so to enable you to take a decision whether or not to proceed? You can't take a decision at a particular time because of the deficiencies that lie in the affidavit. And the engagement with the referee would then, I take it, enable you to look at what you've now collated holistically and say, yes, I have a basis to authorize an investigation. Would I be correct in that conclusion?
That is correct.
Now,
Council, before you proceed, may I just respond to something, Chair, a request that I had made prior to tea. There is no need. I take the points that were raised by Commissioner Baloy, and I leave it where it is in terms of whether or not I should still look at the application for the Section 2813.
Thank you, Advocate Johnson.
thank you, Chair. Thank you, Advocate Johnson. So then we know, but by December the 6th, 9th, apologies, by December the 9th, somebody in the IDEC team now has the dockets. And we assume that they would have read those dockets in the same manner that the legal services of SAPS did and arrived at the same conclusion. That's an assumption on my part. I don't see a basis on which they would arrive at a different conclusion. Would that be a fair assumption?
It makes sense, yes.
Yes. So, according to the docket, as far as we know, the next piece of information that comes in is Mr. Adams's A1 statement, which is the first document in this inquiry file. And that you will find at Exhibit 1, page 683. Exhibit 1, Exhibit File 1. And
File 3.
File 3. My apologies, I mixed up my files. And unfortunately, we will have to keep file 8 close by. But I'll not call it immediately. They'll assist you with that file, advocates. Do you need to? Yes, but not immediately. We'll get to it shortly. So we know that what we have at page 683 of the exhibit bundle is this statement by Mr. Fadil Adams, which is dated the 6th of January, 2025. If you look at 684, and it was commissioned by Dylan Perumal, that is Chief Perumal, correct? At least that's what
That is what I see, yes.
yes,
correct.
Colonel Padiachi told us. Now, if we go to paragraphs 2 and 3, my assessment is this is the additional information the investigators obtain from Mr. Adams. Now, if we look at paragraph 2, He says in early October 24, he received information anonymously surrounding alleged fraud and corruption being perpetrated within the Division Crime Intelligence of the South African Police Service. The allegation related to a certain high-ranking police official being involved in manipulating promotional and security vetting processes to unduly benefit a civilian person who worked for BMW South Africa before being appointed as a brigadier in CI. She apparently has no policing experience and no management experience, and was appointed as the head of the technical support services. At 3, then he indicates that he was informed that there were several highly skilled and qualified senior police officers who applied for the post but were overlooked by the CI management, who favored Mrs. Mukwele over them. The generals involved are Kumalo, CI head, Lushaba, CI, Madondo, CI, Legalagala, CI, amongst others. That is the totality of that statement.
I see that.
Would I be correct to assume that at this juncture, now that the referee has been given an opportunity to amplify their original Section 27 affidavit, this would be the point to consider what you have on the table and to determine whether a case has been made out for an investigation?
That would be correct.
Now, considering a highly deficient Section 27 referral, dockets that say almost nothing from the perspective of determining whether or not the an offense has been committed, and if so, by who. Read with the contents of this statement, do you think the referral even gets anywhere close to complying with Section 27?
Sorry, apologies, Commissioners. I only see the statement now, so if you'll just grant me a moment.
Take your time.
Council, in my assessment of this reading, together with the Section 27, it creates a sufficient enough basis for an investigation to go forward.
And I take it to say so because unlike with the original affidavit, we now have the grounds upon which the suspicions are based.
That is correct.
And the grounds you find where in the statement?
They do refer then to the allegations of fraud and corruption. They say where, they say what the allegation is. The allegation related to certain high-ranking police officials being involved in manipulating promotional and security vetting processes to unduly benefit a civilian person who worked for BMW South Africa before being appointed as a brigadier. She apparently has no policing experience, no management experience, and was appointed. And paragraph 3 going on to say that there were several highly skilled and qualified police officials who applied for the post and were overlooked in favor of.
Yes.
I take it from that reading.
And that latter part, we know paragraph 3 does not invoke the authority and jurisdiction of IDEC. The fact that in the course of recruitment, some more deserving candidates were overlooked is neither here nor there for IDEC. So the only thing we have is what's set out in paragraph 2.
Correct.
And paragraph 2, if it can even be said to set out the grounds, speaks to manipulation of manipulating promotional and security vetting processes to unduly benefit a civilian. So it has become significantly narrow now.
I hear you.
Is it not at this point that you revisit your December the 6th authorization? You remember that we looked at it, file 8, page 3282, which set out a litany of possible crimes and a list of people who must be investigated, is it not at this juncture you revisit that decision and you say, now that the issues are clarified, I'm happy that the referral in its totality now is complete and grounds have been advanced. I can only support charges relating to manipulation of promotional and security vetting processes.
So on my reading
Yes.
of paragraph 2, what it says is that an investigation can go ahead to determine whether or not there is veracity in the claims made in paragraph 2.
You say, Mr. Adams, no, Mr. Adams can instruct you to.
No, I didn't say Mr. I'm saying that the information herein is, for me, these are the allegations as they are now being made out a bit more clearer. These allegations should be investigated, whether or not they support his allegation or not. It is at that juncture, counsel, that one is able to make a conclusive decision to then stop that process, because there are allegations being made. If they are not followed up, we could have been accused of not having conducted further investigation. That is just my assessment
Okay.
of where we are.
Sure.
Advocate Johnson, you remember your and my engagement of yesterday about factual conclusions that are lacking in factual substratum supporting the factual conclusions.
Yes, Chair.
I will suggest this to you. I see the content of paragraph 2 to yet again make factual conclusions, which to my mind are not different in substance to the factual conclusions we dealt with yesterday.
I understand.
And do you agree?
I agree.
So I do not see the basis on which you would, based on this affidavit, have come to the conclusion that now there is enough for an investigation to be conducted. If you accept that these are factual conclusions that are not supported by factual allegations that support the conclusions. So I do not see how you get to the answer you gave to Ms. Silolo.
Chair, that was just my reading and understanding of it. And I indicated I see this for the
Yes.
first time today.
Yeah,
However,
but,
I
yeah.
follow the sequence of the reasoning
Yes,
that is made by the
and
chair.
Do,
And
do you do you agree with the suggestion
I
I'm
agree
making?
with your suggestion.
Thank you.
Thank you, Chair.
Can I just
Yes.
draw to Advocate Johnson's attention? Advocate Johnson, appointments to senior management at SAPS level are governed by National Instruction 11 of 2017. And it appears to me that IDEC is not even familiar with this national instruction, because when Colonel Padayaki was here, he struggled to give answers in relation to this document. Yet this is the document that governs every step in the appointment of individuals such as the brigadier we're talking about here. And clause 17 of this document, I hope it has been provided to you, the national instruction. I see the attorneys seem to have stepped out, but it's National Instruction 11 of 2017. I had asked that a copy be made for you. Maybe this is, yeah. Is that? the second last page, clause 15. Just look at the first page first.
The one that starts with the purpose.
No,
Commissioner
look at
Khumalo?
the cover page. It
National
says National Instruction 11 of 2017, appointments to posts in senior management service.
I see that.
And then if you go to clause 15, which is the second last page,
I am there, Commissioner.
yeah, it says if a candidate is appointed and it appears that the candidate did not comply with the requirements of the appointment, that's paragraph A, we can skip B because B relates to the non-disclosure of criminal record and goes to C. If it appears that the candidate provided false information in his or her application or letter of acceptance, or D, the candidate is unable to take up the post. Look at what follows. The matter must be reported, and I emphasize the must be reported to the Divisional Commissioner Personnel Management for a recommendation to the National Commissioner on whether or not the candidate may retain his or her appointment. Do you see that?
I see that,
So
Commissioner.
the prescripts at SAPS govern a situation where an allegation like this is made, that because IDEC is not qualified to determine whether somebody qualifies or does not qualify. If such an issue has arisen, it then gets reported. In fact, it must be reported to that person so that that person can investigate and then make a recommendation to the National Commissioner, because it is the National Commissioner of Police that appoints people to this post. Do you see that?
I see that.
But it bothers me that your investigator, because I don't think this would have been brought to your attention, but your investigators did not even pay attention to a
The
national instruction which governs appointments at this level. And later on, when we go through the provisions of this document, you will see that it governs how panels are set up, who recommends, who approves. It governs how candidates are interviewed and scored. It governs how the recommendation to appoint is then made and who recommends and who appoints. But your investigators say nothing about this. In fact, they pay no regard to it, because even the definition of what is appropriate management experience, not management position, don't confuse the two. Appropriate management experience, the only place where you find that definition is in this document.
Okay,
And your investigators, for reasons that are not clear to me, paid no attention to this and proceeded instead to target a civilian and deal with her in a manner that I have serious difficulties with. So going back to the affidavit, because it goes together. So let's go back to the affidavit. It goes together with the cover page, because the cover page on 682 is described as the statement. And the reason why you have an affidavit is because everything Mr. Adams wants to say cannot fit in this page, on this page 682. So the affidavit has to be an annexure to this page, which says South African Police Service Statement, and then has description of the offense, where the offense took place, what the offense is. So if you just look at the particulars of the offense, it says the date of the offense is October 2024. Do you see that?
I see that.
So there's a specific date. And then it says the scene of the offense. It says it is at Crime Intelligence Offices, Priska Street, Erasmus Kloof, Pretoria. Do you see that?
I see that.
So that's what Mr. Adams limits himself to, because this document gave him options. You will see when it talks about date and time of the incident, he could have chosen the starting point and the end point, but he limited himself to a particular date. And then same with the scene of the offense. It gives him the option between, did it start in Cape Town and continue and conclude in Pretoria? But he limits himself to a particular date when a particular decision was made, and he says, that is the offense, that is the date of the offense. It took place at crime intelligence offices. Do you see that?
I see that, sir.
But IDEX investigation goes to April, it goes to May, it goes to June, and it targets this individual civilian in circumstances that are simply not justified by the referral or the statement or the affidavit itself.
I see that.
Do you want to comment? Because we'll come back to that later.
I see that, and I see that once you read the national instruction of the police. I see the point that you make.
Even on panels, it's very clear. If there's a problem with a panel, there's a procedure for that. If there's a problem with a shortlisting, there's a procedure for that. And this document governs all those things.
I take the point. I see the point.
Thank you, Commissioner Kumalo. For the record, that national instruction for future readers is at file 3, page 706. Exhibit file 3, page 706. Now, staying with the statement then, the second statement of January 2025. Do you still have your second statement, the A1 by Mr. Adams? You recall I said it's page 682?
Yes,
Yes. Now I'm still at paragraph 2.
of
Yes.
683.
683, thanks.
Thank you.
Yesterday day before yesterday, I've lost track of time now, I apologize. But you highlighted the provisions of section 29 of the NPA Act and 29 capital A, which states an investigator may, subject to control and direction of an ID, exercise such powers and perform such duties. I'm interested in that phrase, subject to the control and direction. And my proposal to you is at this juncture that you do quality control or quality check to determine whether to proceed with this investigation. And in order to do so, you must satisfy yourself that whatever is described in the referral affidavits and firstly complies with section 27 of the Act, but most importantly, brings you or brings that complaint within the confines of section 7. Remember section 7?
Correct.
That we dealt with. Now that we are here, what about all these documents leads you to a conclusion that this matter relates to serious, high-profile, or complex corruption, commercial, or financial crimes? As Commissioner Kumalo points out, whatever is clarified by the second statement is that this is about employing a civilian. And there is a process in terms of a national instruction to address that issue. So it cannot be, I suggest, that employment could come anywhere close to section 7, capital A. How do you get there? We are looking at the same information, you and I now. And I conclude that you could not reasonably have come to the conclusion that we are now within 7A. I want to understand how you get there.
So, Council, I get there in terms of the allegation of fraud and corruption and the unduly benefiting of a civilian. Hence, I said initially, I'm not going back on agreeing with the sufficiency hereof. At the time, the assessment is whether there is fraud and corruption and whether someone unduly benefited. and that it does allow for further investigation.
So you're suggesting that you went by section 7, bracket 1, capital A, B. You say that what the referral points out gets nowhere close to the provisions of sub A. So this is just sheer forgery. No, you said fraud and corruption.
That is correct.
So you skipped A, the requirement that the matter must be serious, high profile or complex corruption, commercial or financial crime cases. You completely ignored that part.
Not ignored that part, that it falls within the ambit of the 7B.
But then what is so serious, high profile, involving complex corruption, commercial or financial, in what we have just looked at?
It is in the main, the fraud and the undue benefit.
What's complex about those?
No, not that it is complex. If you'd allow me to.
Oh, no, my question was, I took it that IDEX mandate is in the main captured in sub A. So firstly, you remember we had a conversation about the determination of whether when a matter is brought to you, you must, a determination of whether it's serious. Now, we may differ about how it should be read, but one would expect that high profile or complex corruption, commercial or financial, they must feature somewhere in there. Now, I want to know, now that we are here on the 6th of January, what is so serious, high profile or complex corruption, what is commercial, or what exposes a serious commercial or financial crime? Because I would suggest, absent that, then IDEC ought to walk away. What's your response?
So if I could just first indicate where I saw that it fell, and I have a response to.
No, you'll come to where you saw it fell. You have to, at least for my benefit, get us past A, which is your starting point.
Yes. So for
Now-
me, counsel, that even if you don't have A, there is B, which relates to the fraud, forgery, uttering, theft, any offense involving dishonesty. That is my reading of where it fell.
So you read this section to provide the Office of the Investigating Directorate shall carry out any functions incidental to investigations, and we have A,
Yes.
the serious high profile, or relating to fraud, just like SAPS.
Yes.
No difference between you and SAPS.
No.
No difference between you and Hawks.
No.
What are the various mandates of these institutions, if you also overlap? And I read B as suggesting relating to additional related offenses. So it's additional to something, and I suggest it's additional to A. IDEC's entry point has got to be A. In the absence of that, I don't see how IDEC gets to investigate.
If you look at,
Maybe, Ms.
sorry.
Maybe, Ms. Johnson, as you answer the question about your mandate, you should also have in mind and speak to why IDEC was formed in the first place. We always had the SAPS, which had always had the mandate to investigate fraud, forgery, uttering, and all of that. So maybe consider also why was IDEC formed in the first place as you answer what is your mandate and how you interpret this 71A.
Okay, Commissioner. So under capital 1A, we have relating to serious, high profile or complex corruption. And then it has commercial or financial crimes. And that then takes you to the additional, which is in B, which is fraud. There is nothing about the serious, high profile or complex corruption is precisely what we were formulated for, Chair, is to deal with serious, high profile, complex corruption matters in the main, the related offenses, but to deal with those that arise from the commissions of inquiry, the state captured, the party and the Nugent, and then other matters that may be referred to IDAC, be they section 28(1)A or by section 27. But the main gist of the question by Commissioner Baloy is IDAC was formulated to deal with serious, complex, high-profile corruption matters.
And you say a theft that SAPS can investigate is a matter that IDAC was formed to investigate. And I want to give, I'm going to give you a truly ridiculous example, a theft of a motor vehicle. If Mr. Adams had referred to that in a section 27 and said a vehicle was stolen, are you saying that you would be entitled to investigate it under B?
No,
Why? Why not?
because that matter falls within a different mandate, and that matter falls within the mandate of SAPS. If you'd allow me to just, and then I know
Yeah, no, you can
I
expand.
know you'd have, relates to a very specific environment. It relates to the crime intelligence environment, and it relates to the theft of the secret funds or the slush funds, as he put it.
No, but that's not what he's saying in that paragraph 2. Remember, he gave you this affidavit, section 27, which contains no facts whatsoever. We've agreed that. It
Yes.
contains no factual material. That's why you went to him, or Perumal, somebody went back to him to get further clarification or further detail. Now, the grounds to support the suspicion. And all he comes out with is that paragraph 2, which is about unduly benefiting a civilian who did not qualify when there were 3 other people. What does it have to do with your mandate?
Commissioner Baloy, from what I understood, and the investigators will have to give the detail, I understood as follows, that when they got those dockets, the 4 dockets, they took additional statements in each of those dockets. This would have been the one that relates to the allegations of the appointment, but that there would have been other statements that would relate to the theft of the funds, etc., that would take that matter differently. But that is the information I have, as they took additional statements, Chair, per docket. This matter for me relates to a very specific.
So, yeah, even with that, I mean, we can limit it to this specific matter, and the question remains, what is it about this specific matter? You say there are other files or other dockets. That's where we will find that it falls within your mandate, but we are talking about this specific docket, that on this docket where this statement belongs, if all you have in this docket is the section 27, and then you have this statement, it looks like this is a matter that belongs to the SAPS at best. And we have that national instruction that tells the SAPS how to deal with this matter.
If I could just add that from what I understand, that after the investigations continued, the docket doesn't consist only of. Whether or not that is sufficient is a debate. But if you take it just on this and just on the section 27, it goes back to the question that council asked, as well as yourselves, Commissioner, then it should have fallen within the national instruction of the police.
But remember also that at this point, you have already made a decision to investigate. And I don't mean to reopen that debate that we've had, but this in fact is now part of an investigation because you have already made the decision to investigate. So even if you had sight of this post the decision to investigate, it has no consequence to your decision because you've already made the decision to investigate. And when you made the decision, you didn't even have this. This, in fact, further clarifies that this grievance as relates to this employee in particular and her ending up being charged is really a grievance about someone having lost out on an appointment, and it's no more than that.
I see the point you make, except that I just go back to the answer I gave, that more investigations were done, Chair, and it is based on the more investigations that were done that would have then translated to the charge. As it stands.
And the charge of gratification against her.
Yes.
Okay.
So, but as it stands here, I took the point and agreed to the point that if this is all that there was, then it does fall under the national instruction and should have been elevated, Chair.
Okay, thank you.
Let me invite you, Advocate, to engage in a close interpretative exercise. As Ms. Silo touched on it, paragraph B of subsection 1, uppercase A, refers to additional related. I want you to please give meaning to additional. Additional to what? And to also give meaning to related. Related to what? Can you please do that?
So just on my reading,
Not just your reading.
on a reading,
Yes,
yes, the related to additional related offenses, Chair, read from paragraph A above, is relating to serious, high-profile, or complex corruption, or commercial or financial crime cases. I take the commercial or financial crime cases relating to fraud, etc. That
So at least you accept that IDEC cannot just jump and investigate any fraud, any forgery, any uttering, any theft.
not from the reading of the act.
So it must be additional to what's envisaged in paragraph
There must
A.
be a relationship with paragraph A.
Okay. Oh, all right. I just wanted to be sure. Thank you.
Thank you, Chair. Now, on that understanding, we have this section 27, we have the dockets, the A1s in the dockets, as we now have come to learn. That was the only thing that was in the dockets. We have this latest A1 statement from Mr. Adams. Then can you please indicate what those documents collectively, how those documents collectively land you at A? We know their contents now.
Sorry, Council, repeat.
Those documents, the original section 27, the A1s in the respective dockets, which is what the legal advisor at SAP said, that's all that was contained in the dockets. And I assume that is precisely what you found. You couldn't have found any more than the inspectorate had. And thirdly, Mr. Adams's January statement, the one we're looking at now with 2 paragraphs. What in any of those documents collectively led you to the conclusion that the documents disclose serious, high-profile, complex corruption, commercial and financial crimes?
I'm saying, Council, that it's not restricted to those three because further investigations were done and it is on a reading of all the investigation in its totality that led to
Okay.
the charges as they were preferred.
The thing, you have rushed to the charges. Remember that we had said the section 27 was incomplete. You exercised your discretion and you say you normally do, which is to request further substantiation from a referee. Now you have it. And we agreed in the morning that that is for purposes of you determining whether to even initiate an investigation. And in order to do so, you must first establish jurisdiction, that you have that jurisdiction to entertain this claim. What, as they stand, is that not your point to have asked yourself whether this complaint at least squarely locates you within A? And I say this because it can be that you investigate with the hope that somewhere, you will come across some damning facts that will then justify A. We first have to be in A before you investigate. Otherwise, the process is deeply concerning.
On a reading of those documents, I'm not going to be able to take my point further than indicate that based on the fraud and the undue benefit and the fact that it is commercial and or financial crimes, we moved from A into the B. And that therefore justified investigations continuing. We're not there at charges. It is based on these documents that you refer to, Council.
Advocate Johnson, the section 27 doesn't contain anything that is a basis for you to say, yes, there's a financial crime possibly that is being committed that requires further investigation. It doesn't contain that. It doesn't contain, so let me see, it doesn't contain anything where you say any facts. We settled that all that affidavit does is to list suspicions. It doesn't say what is the basis of those suspicions, which we all agreed sub B, 27B, requires that there must be grounds for it. Otherwise, you are going to be fishing, you know, and I don't think that's what your powers are meant for. So we've agreed that affidavit doesn't contain any matter that takes you to a place on its own where you end up saying, yes, that which is contemplated in one capital AA, which is serious, high profile or complex corruption, commercial or financial crime, it doesn't contain those kind of facts that ground the suspicion. You then go and get an affidavit, or your people go and get an affidavit. All that affidavit does is tell you that a civilian was unduly benefited over employees within crime intelligence. That's all it tells you. But this is later. This is an affidavit in January. So it's actually irrelevant for purposes of your decision, what triggered your decision. Okay. All you had to trigger your decision was the section 27. And on the section 27, you could not have had a reasonable basis that there is the commission of a crime. And your explanation since yesterday and today, and I must say the same with Colonel Pariachi, is it seems your office or IDEC took the view that we have an affidavit, vague as it is, we go fishing, we'll find something. There must be something to find. So you went in either because you had been told, which is not in the section 27 affidavit, you had been told there is something to find. It's just not contained in the affidavit and you went looking for that. Or you went not knowing at all that you'll find something. Which is a typical fishing exercise. Your mandate and your powers don't contemplate you doing that. That's why there's that trigger provision. But in this case, it seems there was a failure in that trigger. You just did not have enough to trigger that investigation. And the question that eventually must be asked and must be answered is, why would you do that? And it's a question that is qualified to be asked because we are dealing with an organization which has lawyers in it. We have you who has experience in what this act deals with, the powers that it gives you. You have prosecutors, you have a lot of people. It's simply unimaginable that in your office, no one would have said to you, ID, we do not have the triggering requirements. It's simply unimaginable that no lawyer in your office said we don't have jurisdiction to investigate this. And maybe let me ask you the question directly. That you went as far as you did, does it mean no single lawyer in your office said to you, we don't have jurisdiction to investigate on the basis of that section 27? And even after you received this affidavit, no one said, we lack jurisdiction.
No. And just to perhaps then indicate that based on those three documents, section 2813 of the NPA Act says that if the investigating director considers it necessary to hear evidence in order to enable him or her to determine if there are reasonable grounds to conduct an investigation in terms of subsection 1A, the investigating director may hold a preparatory investigation.
So you say to us, you had that preparatory investigation.
That is the preparatory investigation that is conducted so that where there is, it is in order to determine if there are reasonable grounds. And when you look at the proposition that is being put to myself, is when you look at these, there's no reasonable or there's insufficient. I'm saying that section 2813 allows us to conduct an investigation to determine if in fact there are reasonable grounds.
I accept that. My question still, after the preparatory investigation was done, no single lawyer in the office said to you, we do not have the jurisdiction to prefer these charges.
No.
Okay, thank you.
And staying with 2813, for process purposes, my reading of it, and I want to test if it's correct, is that if you, as the investigating director, consider it necessary to hear evidence, you do so to enable you to determine if there are reasonable grounds to conduct an investigation. So you're not at investigation point yet.
No, it's a preparatory.
Yes. So 2813 allows you to hear evidence or obtain evidence to determine whether or not there are grounds for an investigation. The point we're making to you, or at least I'm making to you, is as of the 6th of January, there are not even any grounds at all to conduct a preparatory investigation to determine whether to conduct a full-blown investigation because the matter doesn't fall within IDEC mandate. So I get confused by your reliance on 2813, because 2813 is not carte blanche for you to conduct a full-blown investigation on flimsy non-existent grounds.
It is not a full-blown investigation. What it does allow is where we need to still determine if there are reasonable grounds for an investigation.
Yes.
And I'm saying that given what we had at the time is the section 27, the 4 dockets, then we needed to conduct a preparatory investigation in order to determine whether or not there are reasonable grounds to continue with an investigation.
No, so apologies, because now I'm thoroughly confused. Remember, we start with 27. We said the original affidavit received, it doesn't assist you at all. You advise the commissioners that you have the power to call for further information to consider the referral in its totality. Now you've got the flimsy A1 statements in the various dockets, and you have this January 6th affidavit. At that point, you now have a total picture. You must make a call on that section 27. Does it now bring you within section 7 of the Act? Does it bring it within the jurisdiction of IDEC? And I'm suggesting to you that considered collectively, you can't even get into section 7A, capital A, sub A. That's the first. So it's only because it's only once you are in that, you then determine whether, because what you are headed for now is to trigger a preliminary to determine whether to investigate. You are not in full investigative mode yet. You are not intruding into people's lives and their private affairs. It's a preliminary investigation or preparatory investigation that informs whether or not to conduct, because it could potentially end at 2813, and the response coming back is that no, we won't go any further. So that's the second step, correct? Are you with
following.
me? Now, when does the 2813 step end? What must you have? Must you have the full picture of all the crimes that you have alluded to in your authorization of section 2813 before you authorize a further investigation? The levels of investigations have to be different, I would assume.
That is correct.
Okay. Now, what must you obtain in terms of 2813 to help you determine whether to conduct a full-blown investigation?
You must have enough evidence that there are reasonable, that the suspicions are reasonable and that there are reasonable grounds on which to conduct that full-blown investigation. There must be sufficient evidence collected in the 2813 process. It is then, commissioners, that there is an evaluation thereof and whether or not to move into. So the 2813 Council does allow for quite a few investigative mechanisms. And so whilst it is a preparatory investigation, you are able to issue summonses, conduct search and seizures, etc., in order to move into that kind of investigative phase and therefore to collect evidence to make the determination on whether or not there are reasonable grounds to move into a full investigation.
Advocate Johnson, I just want to understand whether you are of the view that your section 2713 discretion is unfettered. I do see the words, if you as the ID consider it necessary, you may then institute the preliminary investigation. Is that discretion unfettered in the sense that it depends purely on what you consider necessary, regardless of the circumstances?
I do not believe it's an unfettered. It is
Can
based
you-
on the.
Oh, yes, yes.
Sorry. It is based on the information that is presented, as was the case with the team, in terms of how they assess and briefing me on that. It's not an unfettered.
No, continue.
Maybe if
Okay.
Chair makes a follow-up point,
okay.
maybe I might be
Okay,
able to clear it.
yes, I want you to, just for a moment, for me to understand as a matter of law, what the fetters are. If you say it is not unfettered, I want, as a matter of law, to understand what those fetters are. Can you give them to me without reference to the facts that we have here? Because what you just did in your last answer was to refer to what happened here. So as a matter of law, what exactly would fetter the exercise of your discretion?
So there would have to be, as we indicated in the section 27, are there reasonable grounds to suspect that an offense has been committed, the grounds on which it is based, and additional information. In the main, that is what one considers. And any other additional information could then be whatever else they've brought to the fore. And I say that that is what determines it in terms of the discretion on whether or not to move. Sorry, Chair. Also, if we had asked for additional information in order to augment the section 27, whatever that may have been. And that guides the discretion whether or not, given what we have, it is not sufficient for a reasonable suspicion, but there is sufficiency. And so we can go ahead and conduct a preparatory investigation in order to arrive at.
So absent that reasonable suspicion, if I understand you correctly, you cannot begin to do a 2713 preliminary investigation. So that's the reasonable suspicion is your entry point to 2713, you say?
To the 2813.
2813, I'm very sorry.
Correct.
All right, thank you.
On that score, at file 8, the documents you provided yesterday, file 8, page 3288.
Do I still need to keep the exhibit bundle at hand?
Which one, ma'am?
The one where we were going through Fadil Adams' affidavit, the additional affidavit? Close at hand, but not open?
Closed at hand, but yes, not open. At 3288, apologies. The document goes as far as 3300. And I see it's dated the 30th day of May, 2025. Do you see that?
I've got that.
Okay, now if we go back to 3288, this is an application for an investigation in terms of section 28(1).
That is correct.
So that suggests to me that now we are past the 2813 preliminary investigation.
And that investigations were conducted and further evidence would have been obtained between the period 6 December 2024 to the date of this matter.
If I understand the provisions of section 2813 is that you conduct some preliminary investigations to determine whether to have a section 28 investigation.
Correct?
And I take it what we have at 3288, we're at a point where now we are applying for an authorization to investigate in terms of section 28(1).
That is
So the true investigation now starts.
correct.
Am I understanding it correctly? And that application is made on the 30th of May, 2025.
That is correct.
And as we know, on the same date, at page 3304,
Sorry, 33.
3304, same file. Three 3304 is designations in terms of Section 28(2)A. So you are designating a team in this matter
That is correct.
for the investigations.
For the investigation and prosecution.
Yes. And this team is established, designated by you on the 8th of August, 2025. If you look at 3306.
The designations on 3302
Yes, ma'am.
are the designations dated the 30th of May, 2025.
Yes.
Yes,
No, no, no. 33?
03,
Yes.
yes.
I'm now at 3304.
This would have been where additional persons would have come onto the team afterwards. But the original designation, council, is on 3303. So the commissioners, the 28 is signed on the 30th of May.
Yeah, okay.
And the designation for the persons who are to deal with it are on 3303.
I accept your point, correct? So the first designation is 3302, that's dated the 30th of May, 2025.
That is correct.
The document I looked at, you say, was adding to the
Yes.
designated
So,
team
as
in
happens-
August.
As happens in all matters, if you add persons to an investigation, regardless of who they may be, you must designate them to the investigation.
I'm with you. I accept
And
that.
that
Thank you.
would, just for context for why there is a later one.
Thank you for that clarification. Then,
Sorry, I think Commissioner Kumalo has.
oh, yes, please.
I think it's confusion more than anything. I had understood during your first day of testimony that the designated investigator came to you in February to say, please authorize summons so that we can get these documents in relation to the generals that appear in those summonses. And that was sometime in February. There was also a summons that went to BMW again in February. Now, they could not do that unless they were designated as investigators, because for them to say, I need to go into BMW and get documents and interview BMW people, because that's what the summons said. And that was all in the first or second week of February. That can only mean there must have been an earlier designation appointing them as investigators, because if the designation only happens at the end of May, what were they doing talking to BMW management in February of 2025 and interviewing senior managers at BMW in February 2025? So do you see why I'm lost?
May I explain? So Commissioner Kumalo, when the section 2813 preparatory investigation was authorized on the 6th of December, it also designates persons to the investigation. And because they are designated to that preparatory investigation, they are able to conduct investigations.
May I assist? Please answer that question with reference to page 3282. Same file. You say when with the section 2813 preliminary investigation is authorized, it also designates persons who should conduct the investigations. And that is the document we discussed from yesterday. That is your authorization.
Yes,
And it's followed by 3285.
yes,
You say that's a designation in terms of 2813. Is that the document you reference?
that is
Dated the
correct.
6th of December, 2024.
That is correct.
With those documents, then you may respond to the commissioner's question.
On page 3286, Commissioner Kumalo, is the list of persons that were designated on the 6th of December, so that there are persons designated to conduct investigations. And as I indicated, section 2813 does allow you investigative processes, including being able to interview a witness, subpoena documents, and so on.
So there were two designations / authorizations.
Yes, the first being preparatory, and once that is summarized and done, they then bring together the May application.
Advocate Silom covered, thank you.
Thank you.
Have I clarified it, Commissioner?
You have, thank you.
While I hope you have your act close by. And my reading of 2813, why do you suggest it requires a designation? When I read 2813 with 28 sub 2 sub A, I draw a distinction. Whereas it's 28 sub 2 sub A, that requires you to designate people to investigate. But that's a full-blown investigation now. 2813 doesn't do so, and if anything, it just simply says you, the investigating director, may hold a preparatory investigation. I accept for present purposes that you may delegate that power. But it doesn't require you to establish a whole team of people to investigate. It's preliminary.
I understand what you're saying,
Yes.
Council. But out of practice, we do designate persons to the investigation, preparatory or otherwise, or else it'll go back to Commissioner Beloy's point of you have people running around on fishing expeditions and doing as they please. And how do we account for what was done, who did it? Back to Commissioner Kumalo's question of how do you have people interviewing senior persons, etc. It is the designation assists in identifying persons to be able to conduct the activities that that team determines are for investigation. We have always done a
Yes.
designation for both so that there is accountability and there's responsibility for the activities and for the actions.
And I'll tell you perhaps where that designation in terms of 2813 gives me challenges. We have now agreed that you authorized a formal Section 28 investigation on the 30th of May.
That is correct.
That's when the investigation starts.
Incorrect.
Tell me.
So Section 2813 is a preparatory investigation. It allows you to take statements. It allows you to interview persons. It allows you to subpoena documents in terms of Section 28(6), which is what you would see the investigators had done.
Let's deal with that issue with reference to the wording of 2813. 2813 allows you, as the investigating director, it specifically singles you out, advocate, to hear evidence to enable you to determine if there are reasonable grounds to conduct an investigation. So it's a process to enable you to make a decision whether or not to investigate. Correct?
Correct?
Now, we know that on the 6th, you started the preparatory investigation. And by the 30th, you say there is sufficient material to conduct an investigation. So the actual investigation only starts from the 30th of May. Otherwise, you are investigating with, while you are in the 2813 mode. And whatever exercise you are undertaking at 2813 determines whether or not you should investigate in the first place. So you can't have a full-blown investigation in 2813.
It's not a full-blown.
Okay, now we know that you came to the conclusion that we must investigate on the 30th of May as per the authorization. I don't know if this speaks to the efficiencies of IDEC. By the 26th of June, 2025, less than a month later, after you authorized the actual investigation, that list of people was arrested and appearing before court. So your investigation actually took exactly 3 weeks, not more. What did that investigation unearth that was already not in your files by the 30th of May?
The investigations out of that preparatory investigation would have commenced after the 6th of December 2024.
Yes.
And I do hear what you say, Council, but in terms of the preparatory investigation, I read it with Section 7(3) of the Act that says an investigating director shall be assisted in the exercise of his or her powers and the performance of his or her functions or duties, and lists those people. So it is not the investigating director herself who conducts the preparatory investigation. And the persons designated thereto conduct the investigation on behalf of the investigating director. We go back to what is allowed in terms of Section 28 as an investigative tool. They are allowed to interview witnesses. They are allowed to obtain subpoena and obtain documents, etc. And that is what had happened. So by the time we get to, if I can just take a moment,
Yes.
I'm just feeling slightly lightheaded.
Take a moment.
Yeah. Thank you, Chair. So by the time we get to the 30th of May, there would have been investigations done. What the test is on the 30th of May, in the presentation of the Section 28 application, is a summation of everything obtained to date. Does it now make or create that reasonable suspicion we say was not there in the initial phase? And if it therefore fulfills that requirement, we can then authorize the full-blown investigation.
Okay.
It doesn't mean, may I continue? It doesn't mean that whatever investigation was done in the 2813 process falls away and something new starts with the 28-1. Sorry, Commissioner.
Sorry, finish. You can finish.
No,
Sorry,
no,
I thought you
it's okay.
finished. Okay. Can I just clear my confusion? And maybe I should have done these sentences earlier. At page 3283 of the same file, you authorize a section 2813 on the 6th of December, 2024. And then at page 3300, you authorize a section 28(1)A, preparatory investigation. You say to conduct a preparatory investigation in terms of 28(1)A, and this is on the 30th of May, 2025. Is it, because in both letters, you speak, on the one, you speak of a preparatory investigation in May 2025. You see where I'm reading? At 3300?
That word preparatory is not, I have decided to conduct an investigation in terms of Section 28(1)A. It's not preparatory anymore, Commissioner.
My copy reads to conduct a preparatory.
No, I'm not disputing your copy. I'm saying it should not read preparatory because it is a Section 28(1)A.
It is now a full-blown.
It is a full-blown investigation.
Okay, thank you.
Okay, I accept that. Now, I want to know what investigations were conducted between the 30th of May and the 26th of June when they were arrested? Because only then, as of the 30th of May, full-blown investigations are authorized.
I would have to find out in the break and come back to you about
Okay,
what all
please
was
do.
done, because I can't list what was done after the 30th of May.
And that date
And
is
I know it
key.
needs an answer.
That date is key because there is a reason why the statute distinguishes between preparatory investigations and actual investigations, and provides that you may not do investigations unless duly authorized. You grant the authorization. And section 28 sub 13 allows you to conduct preparatory investigations to enable you to determine whether or not you should authorize. Why I say it's important, it appears to me, and perhaps I'm looking at it wrong, that IDEC used the mechanics of section 2813 to conduct a full-blown investigation, which would render it wholly unauthorized. And then to post facto grant the authorization on the 30th of May, which opened the way for applying for arrest warrants and actually arresting them. So no investigation was conducted after the 30th of May. It was all before the 30th of May. And that has got to be because there are benefits to hiding under the cover of a preliminary investigation, conduct a full-blown investigation, cure that defect by a late authorization, and in less than 4 weeks, be ready to arrest. It's quite curious that you end there. Because if that's how it happens, I'll applaud the efficiencies within IDEC.
I will come back with
Thank you.
the response, commissioners, if that is fine.
Chair, while we await the responses, might this then be an opportune time to take the lunch adjournment? Because I want to finish this point. Thank you.
Yes, we will resume at 2 p.m. Let's
Chair.
adjourn.
or on silent? Thank you.
Yes, Ms. Silva.
Thank you, Commissioners. Advocate Johnson, before we broke for lunch, we're trying to understand what investigations took place after your authorization for a Section 28(1)A investigation on the 30th of May. And you indicated you wanted to consult the records to respond to that.
Thank you, Chair. Council, I did contact the office. I've asked them to put it together, and they're in the process of just putting together a little document that will state between 6 December and 20 May, and 20 May and 27 June. I've asked them to please do that for us.
Why 20 May?
So for the date of the authorization.
30th May.
Sorry, 30th of
30th
May,
May.
yes,
Now, I'm just interested from the 30th of May,
yes.
because we do have the docket 542 of 6, 2025. And I'm saying, on my reading of that docket, I can't find any document relating to investigations post the 30th of May.
I take your word for it.
Well, that's my reading of it, and I accept that I may very well be wrong. We know that that docket is numbered 542/6/2025. And we know that from the cover sheet of Mr. Adams's A1 statement of 6th of January. Would you like us to cast our eye there? That would be
Are we in file 3?
file 3, page 68. File 3, page 681. Now, if we look at that, we see at the top, it's got a cast number there of 542/06. And I checked with Colonel Padiache, and I think many other police officers that have appeared. I'm reliably informed that the middle number 06 relates to the month in which the case was opened.
That is correct.
So I take it the case was opened in June 2025.
Yes, the docket would have been registered June 2025.
And that is a day after you authorized an investigation, at the earliest, the 1st of June. Doesn't state, it doesn't give us the actual date, but best case scenario is that it's the 1st of June, 2025, when a docket is opened.
I take that.
And your authorization to investigate is the 30th of May.
Correct.
So they're already deciding to open a criminal case before proper investigations in terms of Section 28(1). Do you see that? Could have been later in the month of June.
But I do see it's in the month of June.
It's in the month of June.
Yes, ma'am.
And remember, we are chasing the 26th of June, which is the arrest date. And we're trying to understand what happened when, post the 30th of May. Staying on that page, at the bottom of that page is a date. 2025-01-06, bottom left corner.
I see that.
Now, Colonel Padiache explained that this was a preamble, this preamble to the statement and the statement were obtained on the 6th of January 2025.
Okay.
That's his explanation, because I couldn't understand why the docket has got a June date, as we have determined, but the statement seems to be taken in January. He had an explanation for that they open the docket, or they take the statement in terms of this document and will subsequently open an official criminal docket later. That's the explanation as I understood it. And I accept it. I've got nothing to countenance it. So my issue really is, on the 6th of June 2025, already we are into criminal investigation mode. And this is very early during what ought to have been the 2813 preliminary investigation process to help you determine whether to institute a formal investigation in terms of Section 28(1)(a). Do you accept
I'm
that?
with you. I accept it.
And that is where then my challenge lies with this 2813 preliminary investigation and the authorization for the actual investigation. And I suggest that, I'll say the investigators in this case, abuse the Section 2813 preliminary investigation to conduct a full-blown investigation before you so authorize them. They've gone so far as to obtain documents from SAPS to prepare an A1 statement in January.
As I indicated earlier, Council, the 2813, while it is a preliminary investigation, does allow you to subpoena documents. It does allow you to engage with witnesses, and it does allow you to do some form of investigation.
Yes.
Yes.
But at this point, while they are doing that, remember, we are trying to show up the Section 27 affidavit. SAPS shouldn't be involved. This is now an IDEC process. You approach the referee to perhaps substantiate if that's what's required. Why is SAPS getting involved at this juncture when you are still trying to address the shortcomings in the Section 27 affidavit?
The shortcomings, as I understand it, can only be addressed by us obtaining the necessary documentation to either support or to dispute the claims made by Mr. Adams. It is, as he said, the Section 27 doesn't have supporting documentation.
Yes.
He makes his averments. In order to determine whether or not these become a reasonable suspicion, we need to rely on the allegations he's making. And where would we find the evidence of those allegations?
Yes.
And it is for that reason, Council, that one is able to subpoena documents. And it is so that the documents sought were invariably at SAPS.
No, this document wasn't at SAPS. It was created, it was commissioned by Chief Perumal on the 6th of January.
I'm saying the documents that we would seek in order to support.
Oh.
Yes, sorry.
No, you're ahead
Sorry.
of me. I'm still on this statement.
My
Why
apologies.
is SAPS involved in this statement, which is seeking to obtain clarification on matters raised in the Section 27 referral? Why is it being registered at SAPS already when you have not authorized an investigation?
I think I'm
Why
I'm a
is
bit-
IDEC at Brooklyn Police Station opening a case in January 2025?
If I look at the CAS number, Commissioner Khumalo, 542 of 6/2025 is a CAS being opened in June 2025. It is not January of 2025. That's how the CARES number reads. I understand the conundrum then of what is this date here at the bottom that shows a 6th January.
And also look at the name of the station. Don't just look at the date. Look at the
Correct.
name of the station and the form itself. That's a subs form. That's
That
not
is-
an inquiry from IDEC.
No. So when you register a docket, we register it on the SAPS CARES system, and we have to fulfill the requirements of the CARES system, which is to fill out that form. That's the only way I understand you are able to.
That's exactly the question. Why are you registering a docket on the 6th of January 2025 when you are still at the preliminary investigation stage?
I understand your question. I'm begging to differ only because of the CARES number. The CARES number determines, and I'm not trying to be controversial, the CARES number has always been what determines when the case is registered on CARES. So 542 of 6/2025 says that a case was registered at Brooklyn in the month of June 2025. I sit with the same conundrum as all of you do. What is this 6 January 2025? If we're talking about when was the docket registered, it would work on the CARES number. That is my understanding of it, and that is how it has always worked.
Or it means the docket was registered without a case number and a case number was added later on. Because looking at these two documents together, the cover sheet which says preamble to the statement on 681, and then the particulars of the offense, that's the affidavit, that's also January 2025. They go together. And all of that would have been done in January 2025. Yes, the case number could have been added later in June, but the substance of the question is, why is IDEC involving SAPS in January 2025 when it is still at the preliminary investigation stage? So the substance of the question does not change.
And I understand, and I cannot answer why that happened. It shouldn't happen. It should have been when the CARES number was registered. So what I'm trying to get to, Commissioner, is the SAPS, CARES, and any involvement within the CARES system ought to have been in the month of June 2025, not this date of January. I can't explain the date of January.
Because my expectation would have been that you would have an IPID inquiry number, and you would start with that and only get to the SAPS documents in June.
That is correct.
Thank you, Commissioner. Then just to
Sorry,
complete.
can I
yes.
just say that my difficulty with how you explain that a full-blown, what turns out to be a full-blown investigation happens on the back of a decision for a preliminary investigation. My difficulty with that is that full-blown investigation is used to show up an incompetent referral, Section 27, if that's what happened. Because what you had is, you had this wholly inadequate Section 27 affidavit, which on its terms does not make a case that triggers your jurisdiction. You then authorize, as you say you're entitled to do, or you have the power to do, you then authorize a preliminary investigation. And that's where you collect all of this evidence. But you use that to show up a poor referral. So that's not the purpose of your Section 2813 preliminary investigation. It's not to assist what should have been kicked out or not accepted by you because it didn't trigger your jurisdiction. It's not to use that process, because if that's what you are doing, then you are using your Section 2813 process for an unintended purpose. Its purpose is not to fix Mr. Adams's poor Section 27.
Correct.
It cannot be. So If your explanation is correct, that's exactly what happened, then we are again in that territory where, in fact, the section 2813 was used as a pretext to make up a case that Mr. Adams should have pleaded or should have stated in his founding affidavit. And so your people would have acted improperly. They did that which the law doesn't allow to use that process for, which is the point that Mr. Law was making, that you authorize a preliminary investigation, but that preliminary investigation, in fact, is used to conduct a full-blown investigation. Your explanation of it proves exactly that they use the pretext of your authorization to assist, make a case that places Mr. Adams's complaint into your jurisdiction when in fact, from the get-go, it didn't fall within your jurisdiction, at least not in his section 27. Do you accept that, if
I
that's
accept.
what happened?
I accept it.
Okay, thank you.
Thank you, Commissioners. You recall Commissioner Kumalo referred you to the national instruction. I think it's 11 of 2017. Did I understand you to suggest that you were not aware of it? Or perhaps I misheard?
I did indicate that I hadn't seen the instruction.
Okay.
Yes.
Can we go to file 8? And in particular, to page 3255. For the record, that's CJC 389.
3-2.
3255. That should be your, what you call your prosecution note addressed to the
GPP.
DPP. If we go to 3257, I see at paragraphs 9 and 10, is that not the instruction note that you referenced there? The same instruction note that Commissioner Kumalo referred you to?
That is correct.
So you do know that instruction note?
I didn't see the instruction. I know of this instruction because I got this from the briefing from the team in order to prepare this memorandum.
No, please say that again.
So when I prepared the prosecution memo, it is as a result of a briefing I get from the team. So the charges against the suspects were presented to me by the team. And so part of the charges and part of the case is as a result of the feedback I got from the team. So I would have got from the prosecution a memo, a draft memo, upon which I look at it and then compile my referral to the DPP. But I didn't see the actual instruction as Commissioner Kumalo had shown it to me today. I didn't look at that instruction.
So the upshot of what you are saying is that in your prosecution memo, you referred to documents you had not seen.
I did not see this document, no. It is as a result of a briefing by the team
No, no,
and
I-
a memo that I would have
I
got.
accept that there was a briefing. I'm saying the long and short of it is that in this memo, you referred to documents you had not seen.
Correct, sir.
So you did not even know that the section 9 you are quoting, in fact, says what you say in your memo. Because if you had not seen it, you could not satisfy yourself that it says what you have quoted in paragraph 11.
Yes, that's correct. It would have been as a result of the briefing, not of me seeing the
Yes.
document.
So you did not satisfy yourself that what you are quoting in your paragraph 11 is in fact what the instruction says.
No, I relied on my prosecuting team and my investigators.
And then you proceeded, paragraph 12, to state, same document, evidence collected proves that accused 1 to 6 contravene the provisions of the above quoted section to benefit accused 7 without just or reasonable cause.
Yes. And that I would have got from the briefing. It's a briefing that they would have given me and indicated, Chair and Commissioners, how each one is allegedly implicated.
What if they are wrong? You are triggering a prosecution. What if they are wholly wrong? Your investigators and whoever it is you rely on.
My prosecutors and investigators.
What if they are wholly wrong? Because nowhere in this document do you say, I come to understand or I'm made to understand. You're making definitive assertions here, suggesting that you are familiar with the prescripts, you are familiar with the evidence that has been collected, and you confirm that accused 1 to 6 have contravened the prescript. How is that not misleading, perhaps, to the DPP?
No, because I did get a briefing and I have no reason to believe that the prosecutors would have briefed me incorrectly.
But you are making assertions to the DPP on matters you know nothing about.
No, I
And
know.
that's by your hand.
Sorry, I interrupted
Sorry,
you.
I was saying, and this is by your hand. So the DPP reads that as she should to understand that the head of IDEC has satisfied herself, because that's what triggers her response at 3255.
Correct, and I'm saying that I satisfied myself from the briefing that I received from my team.
Okay, now, I would like us to turn to your statement, your October 25 statement. And in particular, I would like us to have regard to page 8, paragraph 24. Now, this is your statement to this commission.
Yes,
You stated 24, following upon receipts of the dockets, the information therein was analyzed. Thereafter, an investigation was undertaken. Is that a section 28 investigation or 2313 investigation?
at that time, following upon receipt of the docket, that would have been the 13.
The 13.
Yes, ma'am.
Then you say the investigation unearthed sufficient evidence, 1, to conclude that there was reasonable and probable cause for the prosecution, and Roman 2, formulation of the charges against Lieutenant General Kumal. So the preliminary investigation pointed to prosecution bypassing a formal investigation. That can only be the case.
In the first part, following upon receipt of the dockets, the information contained therein was analyzed. Thereafter, an investigation was undertaken, that is the 2813. The investigation unearthed sufficient evidence. That would seem to be exactly what it says in that paragraph.
The 2813 investigation.
Because I'm unable to read into it a 28-1.
Yes. Now, I would like us to move to paragraph 25, but the last sentence thereof. No, perhaps the 4th line. I may indicate that there was a series of matters referred to IDEC in terms of section 27 by one Mr. Adams. When the whole picture is presented, they include the following. 25.1. The manipulation of recruitment processes and appointment of persons without suitable qualifications into senior strategic posts in the criminal intelligence unit. Who are these persons? And as you think about that, to what posts were they appointed?
In the one that comes to mind, it is the appointment of Brigadier Mokwele.
Brigadier? Yeah.
Yes.
Who else? Because you're talking again
Appointment
about
of persons, those matters are still under investigation.
And which persons are these? Remember, this is from Mr. Adams's Section 27 referral. So they must arise from that referral.
Remember that, not remember. At the time this affidavit is deposed to, it is now October 2025.
Yes.
By then, the 28-1 has been authorized and investigations have continued, not just in that matter, but in other matters that arise from the complaint. So I'm not restricted, this is not restricted to the 27 of Adams. I may indicate there was a series of matters referred to IDAC in terms of Section 27 by one Mr.
Yes.
Adams. But then when the whole picture is presented, that is, I read it to mean, I meant when the whole investigation is presented, the manipulation of recruitment processes and appointment of persons without suitable qualifications into senior strategic posts in the supposed to be in the crime intelligence unit. The one that comes to mind is the matter that is currently in court. And I know that there are other investigations.
But that picture can only emerge from the Section 27 referral. You say so as much. See, there were a series of matters referred to in the Section 27 by one Mr. Adams, when the whole picture is presented.
Yes,
So that picture emerges from that referral.
that's how I
understand it as well.
I know how you understand it. I say that's what I understand is that we get the 27 referral from Adams, but when you look at the whole picture,
Yes.
this is what that picture shows, and that would be the picture that comes out of the Section 28 investigation.
So you are suggesting that there's further information post the authorization for a Section 28 that points to unauthorized or manipulation of processes to appoint other persons other than Brigadier Mkwele?
That is correct.
Under what number? I take it it won't be this particular case number, so would it be an inquiry number?
It would have to be an inquiry number, which which I must provide to you.
Now that you have brought this matter to the commission, will you please disclose all those inquiry files and their respective numbers?
Yes,
Where the commissioners will determine which persons are these you're talking about?
correct.
Okay.
And
The-
then bearing in mind, no, it is fine. I keep in mind what Commissioner Khumalo said about the standing orders and how matters should be approached. So I will give you the reference numbers for those. But what is very clear is arising out of these engagements, one would have to relook the matters, relook them with that factual and legal positions that were put to IDAC and at least put to myself.
Yes.
I cannot go back, having had these engagements, commissioners. The fact that there are investigations in the office does not mean that they shouldn't be relooked at. However, bear in mind that I'm not vested with oversight of those. What I should responsibly do is put together a report for the Office of the National Director so that whoever's reviewing any and all of those matters does take these discussions into consideration. It would be irresponsible if I do not do that, having accepted what was put to me by the commissioners and the manner in which we engaged.
I know Commissioner Khumalo wants to pose a question, but before he does so, may I correct you? I understood you to say you're not vested with oversight over those investigations. That's got to be wrong. You are the head.
Yes, may I explain?
Absolutely.
On the 19th of June, I approached the National Director and I did ask, I hope Advocate Maga, you have now provided, because I think Commissioner Baloy did indicate that we hear what you say, but where's the proof? On the 19th of June, I approached the National Director on my own, and I indicated to him that it might be best for the interests of IDAC and the NPA that I be removed from the oversight of these matters. The basis for that, commissioners and council, was that on the day prior, there was the media briefing by General Nhlanhla Mkhwanazi. What that brought to bear for myself is that for as long as I am in these matters, the matters themselves are not seen. The focus becomes the ID, or the focus becomes Andrea Johnson. That is not in the public interest. That is not in the interest of justice. I had that open conversation with the National Director on the 19th. The National Director asked me if I am sure, and I said yes, because the matters, as well as the NPA and IDEC, have to come first.
Then, if I understand, the power of oversight is bestowed upon you by the statute.
That
So
is
you're
correct.
suggesting, pursuant to a request you made, you were stripped of that power insofar as matters relating to crime intelligence are concerned. Is that what you're saying? And to whom has the power then shifted?
If I can just go here, because I know that Commissioner Baloyi, you did ask a question about, how that could have happened. And when I looked, after having had the conversation, if I may, conversation with the National Director, he thanked me for my pragmatic approach and he agreed. He then indicated, as he publicly did afterwards, these matters will now go under review. And that is the power of the National Director. I report to the National Director. But if it is in the interest of the NPA, as the National Director under Section 22, 1 of the NPA Act, the National Director, sorry, may I read it into the? The
Yes,
National Director, as the head of the prosecuting authority, shall have authority over the exercising of all the powers and performance of all the duties and functions conferred or imposed on or assigned to any member of the prosecuting authority by the Constitution, this Act, and any other law. And then may review a decision to prosecute or not to prosecute after consulting the relevant director and after taking representations within the specified period by the National Director of the accused person, complainant, and any other party, person or party whom the National Director considers to be relevant. It is on the basis of his powers to ensure the performance of and duties and functions conferred or imposed upon myself as an example of someone employed in the NPA. I make the request. He accedes to the request. He understands that it is in the best interests of those matters, public interest, in the interest of justice. And when he agrees, it's not just you. I agree that the team doesn't report to you on these matters anymore. He says, I remove them. They now fall under the reporting structure of the Deputy National Director of Public Prosecutions, who heads the National Prosecuting Service, Advocate Bell, and as well as the fact that the National Director has appointed, Advocate Maga might help me with the correct wording, I think there is an independent review panel that has been put together to consider not just one matter, but all the matters for processes of fairness and transparency.
As I read section 22, that's the one you just read out to us, that relates to prosecutorial decisions,
Yes,
not investigation decisions.
they are,
And let me just finish. Earlier, you indicated that in the course of investigations post-May 2025, after your authorization, you have come across a number of instances where manipulation and of recruitment processes occurred, resulting in unsuitable people being appointed to senior strategic posts. Those are the investigation files we have called for to try and determine who these are.
yes,
I don't understand section 22 to suggest the NDPP would have authority over those investigations. It's the prosecutorial decision that he is
The
reviewing.
NDPP has the right to review or have to be reviewed the Lushaba matter, which is in court, the Mokwele matter, which is in court, and the matter for which warrants of arrest had already been obtained for Generals Kumalo and Madondo.
And
Those are
that is
prosecution matters.
That is because in those cases, a decision was made to prosecute.
That is correct.
So it's a prosecutorial decision that he's
Yes,
reviewing.
that is
But
correct.
that's not our investigations that are currently within IDEC.
Yes, the investigations that are currently within IDAC, as I said, would have to now be relooked
By you.
by myself.
Okay.
Keeping in mind what was said during the engagements, especially the ones on the appointments. I might have to look as well, commissioners, at in detail if there are, and I assume there would be, standing orders with regards to vetting and make a determination on those matters and submit them through to the office of the NDPP.
Standing order sounds very police-like. You meant national instructions, I think.
Sorry, national instructions, sorry.
Can I just ask the question? Before this Mokwele matter, or apart from this Mokwele matter, has IDEC investigated any employment, appointment, recruitment issues ever?
Commissioner Balawi, no, not that I'm aware of, no.
Thank you.
I really hope Commissioner Kumalo hasn't forgotten his questions. I know, took a bit of a detour. My apologies.
It's not a detour because we're still dealing with 25.1, which is
Yes.
where you were. Advocate Johnson, 25.1 of your original statement to the commission. You say there manipulation of recruitment processes, appointment of persons without suitable qualifications. I think because you had not seen the national instruction, we can accept that you don't know what the processes are because they are set out in that national instruction.
I
Is that
accept
fair?
that.
Is that fair?
That is fair.
Yes. Now, let's look at the suitable qualification. What suitable qualification do you say Ms. Mokwele did not have when she was appointed to this role? What is that suitable qualification that you say she did not have?
I would have to have sight of I can't tell you off my head, I'd have to have sight of the advert.
Go to
Sorry.
file 2, page 178. Can you please flight it?
And because Commissioner Kumalo seems to know all the pages.
No, it's file 2, page 178.
I am there.
Yes,
I
so
would have to
those
read
are,
it.
if you look at item 3.2,
Yes,
on
I
that
have gone
page.
through that one.
so that is the position in question.
Yes.
Do you see that in bullet 1, it requires that the person must have at least a 3-year degree or diploma?
In policing, public administration.
Yes, and then it
Management
says
law,
in
etc.
policing or public administration or criminology or intelligence or electrical or mechanical engineering. Do you see that? Or did IDEC stop at policing and say,
No, no, I'm reading as you, yes. And I don't know her qualifications, but the fact that you point me to that means they must be there.
Stop there, Advocate Johnson. You don't know her qualifications.
I know she has, it was called Megatronics,
Do you know what her qualifications are?
not all her qualifications, no.
So why do you make a statement under oath to say she's not suitable for this position if you don't know what her qualifications are? Why do you make a statement to this commission to say the big picture will show that she doesn't have qualifications? Can I ask that they be flighted so that we can look at them? Can we go to 270 on the same file? Are you there?
Yes,
So that's a degree in engineering, industrial engineering. Do you see that?
I see that.
So already she meets the qualification. Now go to the next page on 271.
I see that,
Are you there?
I am there.
Now that's a diploma in mecha, not mega, mechatronics. Now, what is the relevance of that? That is the core description of this role. If you go back to the advert on 176, you will see that the core functions, what crime intelligence was looking for, is exactly this qualification. Because the description of the role tells you that they want somebody who's qualified in mechanics and electronics and all of those. Do you see those?
I see that,
Yes.
Commissioner.
Now, from 270, I don't want to show her matric certificate. It's not
yes.
fair to Ms. Mukwele, but it's on 272. Please don't flight it. It's quite clear that this is somebody who is very bright. I must say this to you. Before I saw these files, the picture painted in my head was that crime intelligence appointed a receptionist from BMW. That's the picture I had in my head. Until I saw these files, then it became clear to me that this person is not just qualified, but her qualification exceeds the requirements. Now, from 273, which we can flight, it's about 12 certificates that I've counted. Because one of the requirements was that you must be familiar with computers, you must be familiar with finance, you must be familiar with how the public service works. So there's a series of them. I counted about 12. Cybersecurity being one of them on page 281. There's about 12. We don't have to look at all 12 of
Yes,
them,
I'm
otherwise it
just
will
quickly
take
browsing.
the whole day. Now, having seen all of this, do you stand by what is stated in 25.1 of your affidavit that she does not have the suitable qualifications?
So she has must have at least 3 years, an applicable postgraduate qualification, relevant in middle management, learning programs, must have a minimum period of 3 years of appropriate managerial experience in the field of the post. For me, the only one, I'm not disputing what you're asking me. I just want
Are
to.
you saying she's not bilingual and she doesn't have a driver's license?
No, no.
Because those are some
No.
of the requirements.
No.
Do you want to dispute those?
No, must have a
So
minimum.
what do you say? What is the qualification that you say in 25.1 of your affidavit that she doesn't have? What is
Must have
that
a minimum
qualification?
period of 3 years appropriate managerial experience in the field of the post.
Is that a qualification?
No.
Experience is a qualification.
No, it was just a requirement.
Yes. Now,
Yes.
your
In terms of-
affidavit says she does not have the
In
qualification.
terms of the documents that I now have sight of, that is incorrect.
It is incorrect what is stated in your
It
affidavit.
is incorrect.
She does have the qualification.
She does have the qualification.
Now, what your investigators have done in their affidavit to the court, they have said, Ms. Mokwele does not have 7 years senior management experience, and therefore she does not qualify. Now, show me on 179,
It doesn't say so.
where it says you need 7 years senior management experience.
It does not say so in
And
this.
that is the basis for IDEC targeting this female person and subjecting her to criminal proceedings and humiliation. What the advert says is that you must have appropriate management experience. Where does one find a definition of appropriate management experience? Where does one find that? It's in the national instruction. It's in the definition section of the national instruction. And this is what the national instruction says. You must have experience above the level of a supervisor. That's all that was required. If Ms. Mokwele met those requirements, then she complied with the minimum requirements according to the advert. In her application for this position, she lists all those. She goes further and she says, I'm studying for my MBA. Are you aware of that?
No, I haven't gone through her affidavit.
Did you see her application for this job?
No.
Now, if you have not seen her application for this job, how can you make a recommendation, as you did in your prosecution memo, that she must be charged with fraud and this many other things? What fraud has she committed? According to the investigation, let's not go to what the court will decide. I don't want to get into what the charge sheet says.
Yes.
We limit ourselves to investigation that leads to arrests and charges. What
Correct.
fraud has Ms. Mokwele committed that justifies you recommending to the DPP that she must be charged with fraud and state capture and all of those things?
Again, I relied on the briefing from my team, and it's going to go back to what counsel had asked me, that I trusted them implicitly. I now see that the facts as I may have received them then, and I'd have to go back and look at it,
And-
were incorrect.
And they misled the court in many respects because the impression they created was that the panel just did as it pleases. I want to take you to 3 documents that illustrate that above the panel, there was senior HR and people at general level who supervised the work of the panel. We're going to start on page 200, same file.
I am there, Commissioner.
Are you there?
I am there.
I'm going to challenge you before we go to, you described Ms. Mokwele's appointment as a token appointment. It's an unfair statement to make, having not seen her CV, having not seen her qualifications. Can you please, in this commission, withdraw the statement that her appointment is a token appointment? It is an insulting thing to say.
I would have to go further than to withdraw. I would have to apologize that that statement was made.
Because it's one thing to say an appointment is irregular.
Yes,
It's quite another to say it's a token appointment.
yes. I base it on what I was given, but I accept, having gone through this file, that the word unsuitable is unsuitable, and that the word token is wholly inappropriate.
Sorry to interrupt you. Let's look at page 200. What page 200 and 201 reflect is that there was a proposal that a panel be constituted. And that proposal or recommendation had to be approved by the Deputy National Commissioner Crime Detection. But also if you go to 201, you will see that Acting National Commissioner Support Services, Lieutenant General Nkua,
Yes.
approved it.
Correct.
So IDEC must accept that somebody higher than General Kumalo approved the appointment of this panel. Okay, now let's go to the shortlisting itself and the shortlisted candidates on page 222. Sorry, it starts on 221.
I am there, Commissioner.
So what you have here is a request for approval once candidates have been shortlisted. There's a request for approval. And if you look at the paragraph 2, the second bullet point. Are you there?
I am there.
Do you see that is the post section head, technical support services?
Correct.
Now, do you see that somebody higher than the panel actually went through the list of shortlisted candidates and examined whether each of them qualified to go through the interviews? Because in respect of that one candidate, they make it clear that here the requirements are not met and therefore this person cannot be shortlisted. Do you see that? Maybe take your time and just read paragraph 2.1.
I see that one.
And then 2.2.
I see that one.
And you can assume that the next page, paragraph 2.3 to paragraph 4,
Will
are
have-
along the same lines. But look at paragraph 4 before we go to 223.
Sorry, paragraph 4.
Paragraph 4 on 222. It emphasizes the need to comply with the relevance policy prescripts. Do you see that?
I see that.
So SAPS looks at these things. At a level above the panel, there is somebody who's reviewing the work of the panel to satisfy themselves that the panel is complying with the prescripts. And then you go to 223. Do you see that the approval is granted?
Sorry, 223.
223, Lieutenant General Nkua,
Yes,
Human Resource Management, grants the approval. And you need to read that with paragraph 2. So you must go back to 221. I'm going to read it into the record. Approval is hereby granted for the selection panels to proceed with the assessment of the shortlisted candidates for the post, which with due regard to the content of paragraphs below. Do you see that?
I see that.
So within SAPS, there was all that approval. And then we must now, I suppose, go to the national instruction. I won't read the paragraphs into the record. I will just draw your attention to the relevant paragraphs that one must look at when one assesses whether Ms. Mukwele or the panel have done anything wrong.
Sorry, Commissioner, I just need to find my document.
Help is on its way. Somebody's there to help you.
I'm told Commissioner Baloyi took it back.
Yes, Commissioner had given me a copy.
No, just go to file 3. We had
File-
located, I think, page 706.
File?
File
It's
3,
okay, Commissioner, but
page
we
706.
we have found it. Let us not dispossess you. Thank you.
Advocate Johnson, I'm going to go through this very quickly because,
Yes,
so just look at clause 2 or section 2. I don't know whether they call them clauses or sections. Clause 2 of the national instruction.
if Commissioner would rather just give me the page number at the top, is that the 707?
That's correct, that would be 707.
Yes, thank you. I'm there.
Maybe for now, then, just look at B in clause 2.
Done?
Do you see that this is what I was referring you to?
Yes,
And then I'm not gonna read them, just
yes.
clause 6, I'm just highlighting them to you. I'm not going to deal with them. Clause 6,
I see that.
clause 7 deals with the selection process.
I am there.
And then clause 12 deals with the recommendation by the panel.
I see that, Commissioner.
And then let me highlight this, 13 subclause 2.
I saw that.
Do you see that it says the deputy national commissioner, divisional commissioner, regional commissioner, provincial commissioner consent must certify that the process took place in accordance with this national instruction?
I see that.
So at a level above the panel, you have 4 people who are not part of the panel, who must certify that the process
Has been followed.
has been followed. Now, if those 4 people have certified that in this specific case, a process has followed, don't you think it was necessary for IDEC to go ask them, why did you certify? On what basis? What was the reason? Because they would know the national instruction better than IDEC, not so?
Correct.
Advocate Silo, I think for now, I will stop here.
Thank you, Commissioner.
Can I just raise my concern about your 25.1, the affidavit? Even allowing for your explanation that you didn't look at the documents, so you never saw this advert. You relied on a briefing from your investigators and had no reason to doubt them, even allowing for that. The difficulty that I have with your 25.1 is that at the time that you prepare this affidavit,
Commissioner.
is that at the time that you prepare the affidavit for the commission, you now have the full set of documents. You have the docket, you have, as you prepare, and I must again assume that you prepped for this. You didn't rely on briefings when you came here. You looked at the documents, what they say, how did we get to those decisions, what were we relying on, because you know that you're going to be asked questions about this. And if that's what you did, I have a difficulty that you still represent what you state in 25.1. When your dockets, when your documents, all your documents that you requested were collected by your investigators are now all before you, you're coming to the commission, and you still repeat the statement in 25.1, which as Commissioner Khumalo has shown you, it's not supported by the documents that are in your own dockets. And it leads me to one of two possibilities, that as you come to the commission, you come prepared to continue a narrative that is not based on any evidence that was before you, properly placed before you, and underlined properly placed before you, for purposes of your decision then, but also for purposes of your preparation here. Notwithstanding that you're prepared to continue that narrative. The alternative is that you did not do the necessary preparation to be able to give us full comprehensive answers. Otherwise, you would not have said to us in that paragraph that she was appointed as a result of manipulation of processes, and everywhere else in your affidavits where you continue that line. Which one is it of the two? And maybe there's a third. You can give a third.
Yes. In my preparation, and in hindsight, I should have corrected it. I just didn't correct it. I knew that I would be asked and be given an opportunity. In hindsight, Commissioner, perhaps not perhaps, in the manner in which the question is posed, the correct thing would have been rather remove these paragraphs and or insert a different view.
And when you came to testify and prepared for it, did you have any difficulty with the idea that you will come here and you will not defend the indefensible now that you have the benefit of preparing and having had the evidence of for example, Colonel Pariachi, very importantly. And I think I expect that on the back of listening to Colonel Pariachi's evidence, you went about to do your own investigation. You asked questions based on whatever you were following. You asked questions to the right people. Did you have, and I asked the question because it does bother me that you have said what you've said in the affidavit. Did you not get to a point where you thought, well, maybe some of the things that we did should not have happened? And when I go to the commission, I will fairly concede as much.
Which is what I've done now in this process.
Yes.
I'm not defending my process.
Yes. Now I'm talking about when you were preparing to come here, because you're making concessions because as you're being probed, it's not as if you volunteered it. You happily read that paragraph and everything that it represents, every way that you speak about recruitment processes having been manipulated to appoint somebody as part of a capture process, which you're still going to tell us about, as part of the capture of crime intelligence for money laundering to happen. You have repeated that. Your affidavits speak to that. Nothing more, nothing outside of that, or nothing different from that. That's you continuing the narrative that is in the charge sheet, that is in Colonel Pariachi's many affidavits, that was in his evidence. So I ask of you, and I ask of you because you are the head of institution, I accept that in some cases you will rely on your people to brief you, right? Instead of reading documents, because you have a lot to other cases to look at. And in some cases, you may well be excused, not in all cases. But when you're now coming to testify here, and we had a similar discussion about what happened in the ad hoc committee where things were put to you and you said, well, I didn't remember it, but we know there's a record of it. Here again, there's been this repetition of a narrative. Until you are probed, you make the concession. And yet some of the things, in my view, should not even have required you to be probed. You know, you should have come in and said to us, I've looked at this. And either you did not look at this stuff in preparation for coming here, or in my view, you looked at it, but you were going to continue the narrative because that's already what you have said on paper and in other fora. And that's why you stick to that version, because you cannot change it. I struggle with that. And I struggle with that, as I say, because not only because you're head of institution, but also you're a lawyer with obligations to forum like ours, with a full understanding of what an oath means and the consequence of saying things under oath that you had no reasonable basis to believe. I ask in that way, and it is a matter of concern for me that you have continued this way, and concessions have had to be forced out of you, forced in quotes, but had to be extracted from you without you volunteering them upfront. I don't know if you want to say anything to that.
No, I hear you.
You understand my
I
concern?
understand what you said, yes.
Thank you. Sorry, Ms. Sil.
Thank you, Commissioner Baloyi. I don't know if the commissioners have anything else to say, to engage the witness on in regard to the paragraph 25.1, because I would be moving on. So, but if there are questions, I think.
We will come back to the appointment issue, but paragraph 25 for now, because it simply said manipulation of process and suitable qualifications. The part of the qualifications.
As
we've
dealt
covered,
with,
and
yes.
the part of the recruitment process we've covered.
Okay.
We may come back to.
I accept that. Thank you, Commissioner. We're staying with your statement to the Commission, Advocate Johnson, and we're now at 25.2. Remember, this is the picture that you say emerges from Mr. Adams's referral, and by referral, I'll use the expanded definition, which is the referral, perhaps what was gleaned from the dockets and from the subsequent A1 statement of 6 January. So I take them collectively. You say, there was a bypassing of vetting processes, which amongst others manifested itself in a failure to apply for and get top secret clearance where required. Who failed to apply for and get top clearances were required? Is that Mrs. Mukwele still?
No,
Who is this?
that is the other matter that is under review. That is the matter of General Madondo.
Does this arise from the section 27? I didn't read the section 27 to ever reference persons within CI failing to obtain clearance certificates.
No, this arises out of the investigations that were conducted
Yeah, so,
after the 28th.
so when you suggest that it arises from Mr. Adams's section 27 referral, that's a tad misleading, isn't it?
I did explain earlier, and I know we don't agree, that I said I may indicate that there were a series of matters referred to IDEC in terms of section 27 by one Mr. Adams. When the whole picture is presented, that is the investigations, these are the things that they present, and they were then into different investigations.
So then I should assume, if it doesn't arise from the section 27 referral, I should assume in the course of the preliminary investigation, because that's all we have.
Yes,
What you stated, 25.2 became apparent, correct?
correct.
I would assume that that would require a section 28 authorization to investigate. It is outside the Section 27 referral.
Correct.
Did you authorize investigation into the vetting and top security clearances for anyone within CIA? And if so, when did you authorize?
I think that the authorization was one authorization.
Is it part of the pile you gave this morning?
It should be.
Okay, what we received starts from, this morning, what we're looking at starts from file 83280. We can skip that, 3280, and go to 3282. That's the one authorization we dealt with. And this was, that had the annexure of 12 names. File 8.
There must be a,
So they started 3282. The next should follow at 3285. The CJC 390. And then we had 3288. But 3288 is for authorizations in terms of section 28 sub 1. And if we pause at 3288, so that's a section 28 authorization. And this one at 1.1 section suggests that the persons listed in paragraph 1.2 of that document have committed some corrupt act in contravention of the Prevention and Combating of Corrupt Activities Act. I'm reading 1.1 and 1.2 together.
yes.
And this, as I read it, sounds like, if you look at 2.1 summary of facts, this is at page 3289, sounds like that it's in respect of the, I'll call it the Mukwele matter, and for lack of a better reference. The persons you have cited at paragraph 2.1, if memory serves me well, either served on the panel, correct?
Yes,
Or had involvement in the eventual appointment of Mrs. Mukwele. At 2.3, you quote the SMS, and once again, you speak of the employment of the employee and what it is subject to. Then beyond that, at 3291, you then deal with the legislative mandate. So this is about the appointment of Mrs. Mukwele, that authorization.
correct.
Okay, then we can move on to the next authorization. It's at 3299. And this one, it's dated 30th of May as well. This is for fraud at 3299, for fraud and any offense involving dishonesty. Statutory offenses there, once again, in PRECA. And it's in relation to activities within the South African Police Service and Crime Intelligence. And you say here, you have decided to conduct a preparatory investigation. Judging by the date, I don't know if this is a different preparatory investigation or you actually meant a full-blown Section 28 investigation. Is that the correction? You remember when Commissioner Baloyi referred you to a
That was
similar,
the correction.
is a correction, so we should cancel
Remove the word
preparatory. Okay. And in this instance, here you then authorize, you then provide an annexure of the persons who should be investigated. But that's for fraud and offenses concerning involving dishonesty. And then you, if you look at 3302,
Sorry, 33.
02 of the same authorization, it's common law offenses of dishonesty, and then statutory offenses, including but not limited to contravention of corruption and gratification, and contravention of the provisions of, once again, PRECA. And if you look at 3303, once again, this is dated May the 30th. If you go to 3304, it's the next document, that's a designation, I guess, in relation to the Section 28 investigation you have just authorized from pages, from page 3299, am I correct? And you recall that what we are looking for is authorization to investigate members of the CI as regards their top security clearances and their failure to apply for such. And then by the time you get to 3307, those are the two documents provided this morning on your per request. And this is the application for investigation in terms of Section 2813. This one takes us back. And the next one, that's Exhibit 390.5. The next one is Exhibit 391. And that is, those are the two letters that you addressed to General Sintumule, and at 3314 to General Kumalo, Major General Kumalo Detective Services, requesting the dockets. There is no authorization regarding the investigation into the vetting and issue of top secret clearances for the various other members of crime intelligence.
I see that that is not here.
Yes. So will you be in a position to obtain that? And it's one thing to have a Section 28 authorization. It's another to understand, for the commission to understand the basis of your exercise of that power, which would mean the investigation file must be provided as well. Otherwise, the commission is not in a position to interrogate whether or not you exercised your power based on any concrete fact or evidence. And that becomes particularly important, I should point out to you, because in February already, and if you go to file 3, page 936. And you suggest that the authorization into these matters regarding security clearances for other officers within crime intelligence would have arisen after their preliminary investigations. So after you granted your authorizations, and that would have been in May 30th, on 30th May 2025. You recall that?
I recall that.
So now at file 3, page 936, is a summons issued on the 6th of February, 2025. And if you go to 937, it states, under details of the matter or other information, this investigation pertains to manipulation of security vetting processes, which resulted in the unlawful issuing of security clearances in favor of personnel within the division, crime intelligence of the South African South African Police Service. This is in February. So it's not informed by any investigation. At this juncture, the assumption was that it's informed by the Section 27. Now you have just testified that no, the issue of vetting and security clearances in respect of those persons listed at 938 arose after the preliminary investigation and not from the referral itself.
Yes.
That's what you explained. So now, are you able to explain why it is your investigators in February already? Remember, you are still to authorize a Section 28 investigation on the 30th of May. In February of 2025, if you go to 938, why has it triggered a full-blown investigation and issuing a Section 28 summons to obtain the vetting, the security clearances and vetting files for the officers listed in there? At page 938.
See that at 936,
Yes.
it says that the investigation was authorized by the investigating director in terms of Section 2813 of the NPA Act into allegations of fraud and corruption.
But then it can't be, because you've just said that, that we know that 2813 we have arises from Mr. Adams's referral.
Yes, and the subsequent engagement with Mr. Adams.
Yes, and his A1 statement of one page of January. You just indicated that that referral does not speak to the top security clearances of other persons within crime intelligence. You said that it was informed by investigations that IDEC conducted on your authority.
On the 4 dockets that what I did say earlier was that there were the 4 dockets. They retook statements on each of those dockets, and the prosecutor grouped those dockets in terms of the categories of offenses. So the information that we would have had arose out of the 27 with the dockets and the Section 2813 approval that was granted. There wasn't one docket dealing with one matter. So the statement that we did view of Mr. Adams, I agree, relates to one matter. I did say that there were other dockets on which they took additional statements
But,
or amplified statements in
sorry.
order, sorry.
but we agreed earlier that you agree with the conclusions drawn by, I don't know if, let me say, Lieutenant General Kamani, that the information contained in the same dockets is scanty and too vague to formulate charges against any suspect. You said you agreed with that conclusion.
I agree with his conclusion
Yes,
there.
yes.
May I proceed?
Please, absolutely.
Sorry. However, IDEC took additional statements because the statements in the original dockets by Adams were exactly what General Kamani says. They were flimsy. So they took additional statements. That is exactly how I understood their engagement with Adams in January of 2025. That on each of the matters, Council, they took additional statements
Okay.
This would be additional statements from Mr. Adams,
from Mr. Adams, ma'am.
where he then mentions these people specifically as implicated in the unlawful issuing of clearance, in the vetting, in the manipulation of vetting processes, and unlawful issuing of security clearances.
That is what should be in there, yes.
Thank you.
May I add then to the list of documents we request, can we get each and every such statement by Mr. Adams of, you say it was in January 2025?
That is when the engagement took place.
Yes, and you said that I think he deposed to a number of statements.
Yes, that is what the investigators indicate, that they took statements
Then,
for each docket.
We're requesting all those statements.
Mr. Maga is,
No,
Mr.
I don't want to
Maga
leave
is
the
keeping-
responsibility with somebody else. I want you and I to agree.
no, I agree
that
with you. I'm
Thank
just
you.
looking at Mr. Maga to just note while we are engaging. Thank you.
Okay, so then if we go back to your statement 25.3. At 25.3, you remember that you said this is what the investigations unearthed. I take the preliminary investigations because those are the only on record. The appointment of persons not suitably qualified and or experienced as a form of gratification for their collusion later in the looting of state funds, e.g. the purchase of properties. Now let's break it down. The appointment of persons not suitably qualified and or experienced. Is it safe to assume that the A1 statements you are bringing, presumably by tomorrow, would address the issue of the appointment of these unnamed persons? They have to be in those A1 statements.
That have to be.
They would have to be. The second leg is as a form of gratification. Please explain that. I take it because we know the section 27 doesn't tell us. Those statements are going to demonstrate that a gratification was paid. I'm not sure in which direction, to somebody or other.
Can I interrupt and take a step back?
Absolutely, Commissioner.
If the person you are referring to in 25.3 is suitably qualified, so we're turning it around. If that person is suitably qualified, then their appointment cannot amount to gratification.
Correct.
You accept that?
I accept that.
So if we accept that Ms. Mukwele met the requirements that we put up, then her appointment cannot be gratification at that level only.
Absolutely. And if you'd allow me to maybe finish the thought is, as I've indicated, I would have to go back into those matters that are still under investigation and to determine whether or not those aspects raised are then still relevant. Do they find relevance? Because if, in the manner in which we have engaged, if those aspects no longer find relevance in those matters would have to be closed and dispensed with.
Because for one to get to the point where one says their appointment amounts to gratification, one must start at, did they qualify for the position?
We have to start where you
Because
started.
if they qualified, then they were properly appointed and their appointment cannot amount to gratification.
That is correct. Yes, and so both, sorry, Council. Sorry, and so both the vetting processes, those allegations of the vetting processes, as well as revisited.
I think the vetting issue in respect of Ms. Mukwele, we can put that to bed
That
because
is,
Colonel Padiaki accepted that the way CI did it, the way the panel did it, disadvantaged Ms. Mukwele. It did not benefit her because the requirement said she must subject herself to vetting 6 months after the appointment. So the fact that they were doing it before the interview was in fact disadvantaging her, not benefiting her. I think with Colonel Padiaki, we settled on that and he accepted.
yes, I accept that. I'm saying with all other, the averment of persons not suitably qualified and or experienced, and or with regards the vetting, if they still find place in those other investigations not yet completed, those would have to be looked at as a matter of urgency and dealt with.
I don't want to force you to concede that because the other people, the process of their vetting was different.
Yes.
With Brigadier Mukwele, the requirements were clear that it must happen 6 months, within 6 months after. So the other people that you referred to in your summons, I'm not there yet, so I don't want to force you to concede that just yet.
Thank you, Commissioner. It's not a concession. It is a matter of saying, I have heard the argument and I should reapply my mind, given all of the discussions that were raised.
Your response to Commissioner Kumalo that if a candidate meets the requirement, then there couldn't be gratification. I don't know that that is correct in your present case, that kind of answer, because gratification is a quid for a quo.
Yes.
So the way you have constructed the charges against Ms. Mukwele is that she was given the position so that she can do something. So she's been rewarded with a position to do something. And that's something you have described it as capture of crime intelligence. You have described it as such. So it seems to me that on the case that you have, it really doesn't matter whether she met the requirements or not. Your case is this is a precar offense. They have appointed this person so that they can siphon off funds. That's Mr. Adams's complaint, which you have agreed with in the formulation of the charge. So and I don't expect you to do the same thing that Colonel Parachi did, which is, well, we don't know what the offense in the future will, whether she will commit it or not, but the charge itself would have required you at day one to say, and maybe you do have that. I'm not getting into the merits of whether you have a winnable case or not. I'm speaking at the starting point is you formulate a charge, and if the charge is giving someone employment, that's one form of gratification. It's employment in return for something. That provision in PRECA doesn't say someone who's not qualified.
Correct.
It doesn't. So she may well be qualified, and yet she gets appointed precisely so that she can assist to achieve certain ends. So your concession that you are easily making now that, well, if it is a qualifying person, there could not be an offense of gratification. The offense is not just the appointment.
Yes.
The offense is you get appointed because you're going to give something
Yes.
in return. So your answer, you have to amend
Yes.
your answer to Commissioner Kumalo.
The answer talks to the suitability in terms of the appointments and whether or not the vetting processes were met. The additional issue, if in fact related to all and not just to Mukwele, would have to be looked at differently. The appointments of persons not suitably qualified and or experienced as a form of gratification for their collusion later on. I have to see what that investigation says. I cannot tell you that there is in fact evidence that there is collusion. The concession I make is that with regards to suitability, the standing instructions, and the vetting process, those are the matters that I would look at. And
No, I'm not raising with you, certainly not raising the vetting issue. I'm raising a narrow issue with you, which is your answer, your concession to Commissioner Kumalo suggests that you accept that because if it is found that she met the requirements, then we were wrong to claim gratification, that this is a PRECA offense, which is a gratification offense. I don't remember the exact wording of that provision. I'm saying your answer to the extent that you're saying, well, if she did meet the requirements, then we are wrong. And I'm paraphrasing. I'm not saying that's what you said. If your answer is because she meets the requirements, or if it is found that she met the requirements, then we couldn't speak of gratification. I'm saying you are wrong because
Yes.
that's not what that offense is about. That offense is you will prove in court that her appointment, it so happened that you say she's not qualified and you say she's appointed even though she's not qualified. But in court, you will show that this appointment, qualified or not qualified,
Notwithstanding is a gratification.
it's
Correct.
a gratification for what she's going to do. You understand the point I'm
Yes.
making?
No,
You
that-
agree
that
with
does
my?
not fall away.
You agree with my construction?
I can't agree with your construction. That is not that's not a concession. It is to look at the suitability in terms of the advert, the requirements, the standing orders.
Okay, thank you.
If there are, in terms of the other investigations, and I'm not saying there are, in terms of the other investigations, I need to go and check.
Okay, thank you.
I do need to go and check.
Thank you, Mr.
Careful, I was limiting myself only to your paragraph 25.3.
Yes,
I was not going to the offense in section 3 of PRECA, which is what Commissioner Baloyi is engaging you on.
yes,
So the answers to both our questions may be different.
I understand. And I didn't assume
Yes.
that you went beyond
Yes,
just the
I deliberately
suitability.
avoided going to the charges. I was just sticking to your statement.
Yes, I accept that.
Thank you, commissioners, and thank you, Advocate Johnson. For my edification, 25.3, does it apply to Mrs. Mukwele? Or do you think it could potentially exclude her because she might be suitably qualified? How do I read it? How do you suggest I read it?
So we have agreed, counsel, that she is suitably qualified.
So therefore, the remainder of 25.3 doesn't apply to her.
She's suitably qualified and experienced. The appointment of persons not suitably qualified and or experienced as a form of gratification that doesn't exclude that part of why she was appointed, even though she's suitably qualified. Yes.
So then, she is not out of the woods yet, because if you are to concede that she could potentially be suitably qualified and experienced, her appointment in and of itself is gratification for her collusion later in the looting of state funds.
That is correct, yes.
What in the investigation leads you to believe that in the future, she will collude in the looting of state funds? Something in that investigation must have pointed you out to this. What could it potentially be?
So the information that we had at the time was that in the process, she would have been part of a process where monies would have been taken from the secret funds in order to purchase properties, and that her placement there would have assisted that process. That was the contention or the allegation.
As a mechatronics, whatever, I'm trying to understand. I hear what you are saying is restating what is contained in 25.3. You're not giving me a basis for that conclusion. You're already concluding that she will be involved by virtue of occupying that position. And I want to understand what in the investigation leads you, by you, I mean IDEC, to conclude that you give her that job, she's in the Secret Service Fund. And therefore she will be looting state funds to pay, she'll be colluding, I correct myself. I don't know with who with, but to loot state funds and purchase properties. What in those files should we look out for to support the conclusion that you draw, the fear that you express at 25.3?
I'll just have to be given an opportunity to go back and to look into the evidence.
No, you
That
must have
relates.
had it. For you to submit on oath, you confirmed
Yes.
the correctness of this statement when we started. So
Correct.
you must have an idea, and I suggest that perhaps you start sharing it with us. Might not be firmed up. When you return, you will give us the full now facts, chapter and verse. But for now, when you wrote 25.3 in relation specifically to Mrs. Mukwele, on what basis did you conclude that she was going to collude in the looting of state funds with whomsoever?
Commissioners, I ask for a moment.
Yes, please.
Are you thinking of a specific document, perhaps?
I'm just perusing.
I'm not,
Sorry,
I'm not,
Commissioners.
I'm not rushing you, but,
Yes, I'm trying to peruse through the chart sheet to at least refresh
oh,
my
okay,
memory.
okay, please go ahead.
Okay.
I think the commissioners were giving you an opportunity. Have you located what you're looking for?
It triggers, it triggers the recollection. And I'm going to hold you to, I'll have to come back with the chapter and verse.
Okay.
I recall that when it came to where she was positioned in TSS, TSS is a covert environment with a very big budget. And the allegation was that if monies were needed, as an example for the purchase of properties, monies would be able to come out of there. And that if she was asked, because of disappointment, she would have felt the need to act. That was the projection, and that was the understanding of where.
Sorry, as to do what exactly?
Sorry. If monies are required or needed, the technical support services to which she would have been appointed has a very big budget. It is a covert environment. And I think the manner, and I'm giving you the explanation as I understand it, the manner in which funds are dealt with are not as open source as everything else. And so should the need arise for funds to be procured, that would be the environment from which funds could be accessed, for example, for the purchase of properties. That is how I recall.
Unlawfully.
That is correct.
So she would
So-
violate her duty of good faith to her employer. She would breach her contract of employment.
I think the contention, Commissioner Kumalo, if I recall correctly, was because the monies are in that environment, she could be approached to make those monies available. I don't know what would be presented to her for her to make those monies available, but that is where the funds are for her to make available.
But if she's doing that as part of her job, how does that rise to gratification and unlawful conduct? Because what you are saying, that would apply to any person who occupies that role. If they are required to provide money, provided that they are complying with the prescripts and they are doing that correctly, that's not a criminal offense.
No, it
They are
isn't.
simply doing their job.
Yes, if she was approached for access of the TSS funds, knowing that whatever that motivation was, she should not approve that funding.
Yes, but how
That
do you,
is-
how do you leap to the conclusion that she would loot state funds? Because that's what your 25.3 says. If she's approving a request and she's doing it in accordance with the prescripts, there's nothing wrong with that.
Not if she's doing it in accordance with the
Yes.
prescripts.
So what is the basis of your assumption that she would have done it in an unlawful manner?
That she would have been approached to make monies available under circumstances where she would not have made them available.
But how do you know that?
That was because of that environment and because of the fact that from previous matters, not in IDEC, that is how funds were looted. Out of accounts where the funds are within a covert environment. So motivations would be put in for access of that money.
You are being,
Without-
if I may come
sorry.
in, no. No. You are being grossly unfair to Mrs. Mukweli. Now you are attributing conduct of persons she has no knowledge of to her. In the future, no harm. And you are saying you accept that she may be required to access those funds in the course of execution of her job. But the impression you create here at this 25.3 is that she would do so to loot. So that apology that I think you sought to extend to her, you might as well take it back. You are seriously impugning her credibility, and we're trying to find the basis on which you say she was going to loot.
I hear you. That is not the intention. I'm trying to give an example of how I find that space. Of how I find that space. And,
You see,
sorry, if I.
oh, no, you may
No,
continue if you're
No,
not done.
I think it is also wholly unfair. There's no intention to impede on her dignity. I am merely expressing or amplifying on the question. If that is how it comes out, counsel, really, it is unfortunate that you think that I would, in giving an explanation, that I am intentionally impeding on her reputation and her credibility. I do apologize if that is how it comes out, but, and to say that my apology, in fairness, commissioners, that I made earlier, I will not willy-nilly make an apology. The commissioners did not drag an apology out of me. I made that apology freely, and I think it should be taken from where it came. It did come freely.
You see, if there were substance in what you are saying, it would apply across the board. That is to anybody appointed to that position.
Correct.
That must be correct.
Yes.
Yeah, because you have no basis to think that she is different, and that therefore this would apply only to her. So anybody
in that position.
If what you say is logical, anybody would also be susceptible to this impropriety.
I accept that, Chair.
Thank you.
Advocate Johnson, in June 2025, this is exactly the charge that was presented, even in the draft charge sheet to justify Ms. Mukwele's arrest. It's exactly this. So she has gone through all of this over a period of a year. It's not new that for the first time today, you are making this allegation. The memos, the draft charge sheet, and all the documents, this was exactly the issue. And I say this for my part, I have no sympathy for people who loot state funds. And if there are people, whether they are generals or not, who are involved in the looting of the secret account or whatever it is, I have zero sympathy for them. But this case, as Commissioner Baloyi said yesterday, is a serious abuse of power by IDEC to target a civilian. And that's what I have a problem with. My sympathy for her is a bit different to the generals, because if they did what they did, the law must take its course. But we must draw the line where organs that are supposed to protect the public and, work for the benefit of the public are used in this manner to unfairly target civilians. That is just not right.
I understand, hence I made the apology earlier. It does not detract from the fact that there is a case for which they have now made representations. Memokwele
And
as well.
you said, it's not just the representations, there's also the review process.
Exactly,
that you referred to.
and yes, and so in the end, fairness and justice must prevail. So if we have made the wrong decision, then that decision will be corrected. And I'm saying that in terms of the appointment, I'm not retracting anything that I said at all.
I think my difficulty with you is if you should not think that the fact that there's a review process, there's a representation process, and therefore what you sought to do, which is to prosecute, if those decisions are reversed, then all is good. It cannot be that. Our inquiry is really about why did you make these decisions? It's not about the merits of your case. And I think we may not have fully succeeded to steer from talking to the merits, because they're intertwined with your processes, your thought processes, your decision-making process, what you evaluated, and we compare that with the legislative mandate that you have and requirements. So fact that there will be reviews and representations that maybe do succeed is not really of our concern. Our concern is, how do you make this charge, for example, how does that allegation even arise that she is potentially guilty of a PRECA offense of gratification? But not just her. And she has been the focus of Commissioner Khumalo because she's a civilian. But any criticism that comes out of Section 25.3, in my view, applies to everyone that you have charged with an offense of gratification as defined in PRECA. And it comes from, but there are no facts alleged by Mr. Adams, the aunt, not in his Section 27, not in the affidavit, that paragraph 2 that speaks only about Ms. Mukwele's appointment. Nowhere else does he make allegations that form a reasonable basis for you to prefer a charge of gratification as defined in PRECA. That is really the issue, right? And so the inquiry to you is, why did you authorize that? Why did your investigators get to that point? Why did the prosecutor, firstly your internal prosecutor, get to that point? Why did your DPP, who said, I concur with the charges, they are good, what were they working off? So we're still at first base, before representations and before a review. Where does this all come from, right? And on the face of it, so far, between you and Colonel Parayachi, you haven't given a satisfactory explanation, I must say. And I accept that you're still going to give us documents, the statement, the A1 statements, and maybe we'll see from there what were the facts that led to this allegation in 25.3, but also that led to the charge itself. Absent that, if you do not have documents that show the facts on which this charge or this part 25.3 is founded, if you don't have any such documents, then this was an arbitrary decision, not based on any facts. And because of it being an arbitrary decision, it is a use of investigative powers for ulterior purposes. If it is not explained satisfactorily for ulterior purposes, then we have that to ask the question, what was the purpose? I hope you understand,
I do understand.
what I'm saying, yeah. So we still have to answer that question.
Correct.
And hopefully your statements will put to, the A1 statements will put us at peace that, well, there was a basis for that. But as matters stand, I must say, from where I'm sitting, that with everything that is before us and until we get something else, then the exercise of the power to investigate and to charge an offense of gratification under PRECA was exercised without proper consideration, without facts placed properly, and I underline properly, placed before you for this and the prosecutor and all the people that I've listed to formulate that charge. On the face of it, the power that you have, all of you that I've listed, you exercise it for an ulterior purpose, and hopefully by the end of the evidence of the IDEC witnesses, we will find out what was the purpose. That for me is the real issue here. Do you have anything to say to that? Thank you. Thank you, Mr.
Thank you, Commissioner. If then we could jump to paragraph 28, you recall this paragraph when you started testifying 2 days ago, you effected changes and amendments to that paragraph. It currently reads, the picture that has emerged is that the appointment and installation of certain persons. We went through that exercise and you suggested that it's not persons that you refer to as person, and that person is Ms. Mukwele.
Yes.
In certain positions within CI by Lieutenant General Kumalo and his co-accused persons help them strategically to access funding without following proper processes. This is because her, following your amendment, her token appointment would not stop them from their unlawful acts. I think that follows on the conversation we have just had.
And that falls away.
Ma'am,
That falls away in terms of the appointment.
what falls away?
What I'm saying is the picture that has emerged is that the appointment and installation of certain persons, and we agreed that in that paragraph, it refers to Brigadier Mokwele.
Yes.
That the part of the appointment falls away, that those first two lines fall away, and that short of there being documents to prove the rest of the paragraph, then that falls away.
Okay.
But that we must have that evidence, because those assertions cannot not be based on evidence. And that is what I'm
The entire
saying.
paragraph falls away.
then that entire paragraph would fall away if I'm unable to find in the Adams affidavits that the investigators say they obtained per docket, Commissioner Kumalo.
It goes further. Even following IDEC's own investigation in two parts, the preliminary and the
And the-
subsequent one. There is simply no basis for what is stated in that paragraph. No factual basis.
And so I'll take it then, it's a conditional deletion for now, depending on what you unearth in your investigation records.
Only the latter part.
The
if
latter
there's
part
no
of that
evidence,
paragraph.
yes.
The first is already fallen
Yeah.
away. Now, you say by Lieutenant General Kumalo, he's the head of crime intelligence. He's got access to the very funds that you speak of. Why does he have to go through all these hoops to access the funds, as you suggest? As if he is outside crime intelligence. He heads it. He's responsible for that budget.
He doesn't have direct access to the budget. He has to work through the co-accused.
And they all account to him.
No, sorry.
Sorry.
I was just trying to get to the, I think he must be Lieutenant General Lushaba, or is it Major General Lushaba? But the accused General Lushaba. That is where that point relates to. So whilst General Kumalo, Lieutenant General Kumalo is the head of CI, he does not have access, direct access to funding. He has to work through the CFO, who is General Lushaba.
So that then, okay. The thing is, they all account to him. So then, on your theory, they must all be beholden to him, which would mean everybody in crime intelligence, because they are beholden to General Kumalo, will in the future collude, I don't know, perhaps with him or whoever, to loot state funds. That theory must apply to everyone who eventually accounts to General Kumalo.
Incorrect.
Okay,
I
correct me.
say that, and his co-accused being General Lushaba, we say that because of the first matter, which is already in court, where there was a housebreaking, his official equipment is stolen, all of it is hidden, and for a long time, no action is taken. And I refer only to him. We're not talking about everybody else. That would be that would be a vile assertion to make, that everyone else would have been beholden. I say that the CFO, who still remains in his job despite his sorry, it's that time of the day. Sorry, despite his official equipment with state secret information having been stolen, it being pushed under the rug, hence the charges of the defeating, etc., that he faces.
Okay.
And him being the CFO, that is the one person. We say because of those allegations, not in isolation, Commissioner Baloy, but because of what had happened in terms of his own matter. And because he controls the funding.
So what does that have to do with this, that he strategically placed there to loot funds? I don't understand what the treatment of his case by the division, and for that matter, by General Kumalo, if that is the case, how he treated that loss of computer and that whole incident, what that has to do with the allegation that he has been placed, his installation in crime intelligence so that he can help strategically to access funding without following he can help General Kumalo to access funding without following proper process. I don't understand the link that you are creating between how General Kumalo treated the loss of a computer and that General Lushabani is in that division and in that position and will be part of the scheme to loot funds.
It is based, that General Lushaba, because he is the CFO and because his criminality was hidden or swept away for a long time till the investigation, that puts him in a position where we say that should General Kumalo require funds, in
He
all
will-
likelihood, he would comply. Yes,
He will give him funds.
yes.
Okay, you say there's that kind of arrangement between them.
That is the assertion.
Okay.
And if I may just follow up, it must be that it's General Kumalo who has covered up and swept under the carpet these issues affecting General Lushaba. It must be General Kumalo in order for General Kumalo to have that hold over him. Is that the charge that General Kumalo is that the matter in court?
No, General Kumalo doesn't face, I speak under correction, that's not the charge he faces. He doesn't face such a charge.
Yeah, so who did the sweeping under the carpet and the covering up?
We say that at the time, when General Kumalo came to know, there was a time where, when this incident happened, commissioners, the CFO was actually the acting divisional commissioner. He was acting in the position that General Kumalo currently occupies. And the assertion is that when it did come to the attention of General Kumalo, he did not act for this reason. That was the way it was couched in terms of the evidence.
When you say he didn't act, you mean he did not discipline him?
I know that disciplinary action was taken, but well after the fact. I think it was after he was charged by IDEC.
So what do you mean when you say he did not act? Because we've agreed that a criminal case has been opened, there's a docket, so it's a subs matter. Now let's come back to crime intelligence, the internal workings. What is it that you say he did not do and should have done? If there's already a criminal case and he was charged internally in terms of the HR processes. So make us understand what you say was not done.
Commissioner Kumalo, before I call you General Kumalo, Commissioner Kumalo, I'm saying is, for a long time, no action was taken against General Lushaba. And when he was arrested in the IDEC matter, and a report was submitted by IDEC to the National Commissioner as we are supposed to do, it was only then that disciplinary steps were taken. The contention is that the moment the head of crime intelligence, and it didn't have to be General Kumalo, the moment the head of crime intelligence had come to understand and appreciate that this is what had happened, this having been the acting divisional commissioner at the time with a different responsibility, internal action to which the disciplinary should have been activated.
Am I correct that that would have been the national commissioner? Because who was the boss above General Lushaba at the time when you say nothing was done?
He acted for I speak under correction, but I think at the time he acted for a very short time.
Yes, but he could
for
not
a
charge
very-
himself. So
Sorry,
I'm
no,
asking who
yes.
is the person above him who could charge him?
But now you ask me a question.
Is
Sorry,
it not the national commissioner?
He was acting for a very short time. And from my recollection, General Kumalo comes back as the divisional commissioner. I'm just not sure where he was in that time. And I'm saying that when it had come to his attention, and this was well before General Lushaba was charged criminally, that action should have been taken.
Can I? The way that I've understood the structure, and I'll be corrected if I misunderstood it, is that General Kumalo falls under General Sibiya's. I think General Sibiya is, yes, I see my co-commissioners are nodding. So he's got a boss. According to you, this incident occurs while he's acting divisional head. So General Kumalo is not above him at that point. Somebody else in the position of either General Sibiya or whoever would have been in that position that is occupied by General Sibiya today, substantive position, would have been the person that should discipline him. When you decide to charge General Kumalo as arising from the failure to discipline, why are you not charging General Sibiya as well, or his equivalent? Not only because the incident happened under their watch, and they are the ultimate head of the division or that section, and so finally accountable for what happens. Why are you not charging that person? Why are you not arresting that person?
Again, under correction, there isn't I'll check in the charge sheet again, but I do not believe that that is what General Kumalo is charged for. That isn't a contravention that he is charged for.
Remember, you have this overall charge where you say people were placed in these positions. Even, in fact, even in your discussion of this section of paragraph 28, the examples you make, that's why we are mentioning Lushaba so many times. You say because he was not disciplined, he is therefore beholden to General Kumalo, and so General Kumalo, him being the CFO, General Kumalo would be able to access funds through him. Now, if the charge of gratification is indeed a valid charge against any one of them, and with Lushaba, you say the gratification is there was no disciplinary action taken against him, and therefore he would have to do something in turn, he must be charged. He must be charged with that offense because he received gratification. It's not just Ms. Mukwele. Whoever he's going to be doing favors for must also be charged because gratification is a two-way street. And so there must be two people charged for this. Whether it's General Kumalo, whether it's his boss, the question remains is you allege gratification, the failure to discipline. You say that is gratification to someone who is strategically placed, who will assist to loot. And I'm saying, well, are you charging anyone with this gratification? You say not General Kumalo. My question is, are you charging anybody? And if you're not charging anybody, my question remains, well, it's a predicate offense according to you to loot criminal crime intelligence funds. Why is no one charged then for that future offense that might happen, might not happen?
I have to come back to you because I've got to go through the charge. I'm not sure that no one is charged,
Okay.
or I'm not sure who is charged.
Okay.
But either way, your question, I understand it.
All right. No, so I accept. Go look it up and then you'll come back and tell us who's being charged with this. But I want to leave it with this proposition that if no one is charged for this, no one at all, one. Two, if whoever was his superior at the time that this incident happened is not charged, and
Why not?
subsequently, why not? But also, it seems it would suggest preferential treatment, that there's no consistency in how you treat offenses. Some you charge for gratification, others you don't. That's where I'm coming from. So when you look it up, prepare that, we'll have the discussion, further discussion along those lines.
Okay.
Thank you.
Thank you, Commissioners. Chair, I know my time is not looking good at all, if at all. May I impose 5 minutes literally just to close this topic because I move on to something else next time I start. Thank you. Now, lastly then, for our purposes today, Advocate Johnson, let's have regard to paragraphs 27 and 26 of your statement, and I take them in reverse order. At 27, you say, when one looks at all the cases referred to IDEC by Mr. Adams, they depict the capture of systems and process for private interest by the head of CI, I take it that's General Kumalo, correct?
Correct.
Okay, and other senior managers. Then you say this too is an issue you intend to testify about. At 26, before that one, you state from second line that if leave to testify is granted, I will get an opportunity to expand on the issues to which reference is made above. And I think that's the exercise we have just tried to undertake, but it's got a second leg to it. You state, I quote, state capture is a type of systemic political corruption in which private interests significantly influence a state's decision-making process to advantage or benefit of certain individuals. Now, in light of what you state at 27, and reference to Mr. Adams's complaint, say the investigations, I'll take it the investigations, not only his complaint, depict the capture of systems and processes for private interest by General Kumalo and other senior managers. I would like you in 5 minutes, literally, if you can, to explain to the commissioners that the capture of systems and processes for his own private interests by General Kumalo, and relate it to the question of state capture that you reference at your paragraph 26, explaining what relevance that has to the terms of this commission. In 5 minutes, if you can, however briefly you are able to. Thank you.
So having had the discussion we have had in terms of the preceding paragraphs about appointments, suitability of appointments, the placement of individuals, and what that placement would have done is what these paragraphs allude to. But when you go back to the discussion we have had about the policies and the prescripts, it becomes clear that the persons that we thought had been put in certain positions for certain purposes, leaving out the gratification portion, which one must still look at, then that in fact is then not the case.
Then let's look at 27. What about the capture of system and processes for private interest by General Kumalo? Does that remain? Is there evidence that General Kumalo has captured systems and processes for private interest?
That would fall away in terms of the discussion we've had, because a lot of it in the main revolved around, and I hate to do this, Commissioner Kumalo, it does revolve around the appointment of Brigadier Mokwele, which we have now dealt with. That was the systems and the capture. Those were the allegations.
So then it would be fair to say we hold these issues in abeyance until you have checked your investigation files and you see if, okay.
Absolutely.
I'm happy to do that.
I must check the evidence.
Yes.
And then come back with a conclusive answer, because what I base it on is in not just the briefings, but that in the briefings, this is the evidence that was presented in the way they present them to the ID. So I would satisfy myself.
All right, I'm happy to flag it until next time. Thank you, Advocate Johnson. Chair, I have a little bit of a crisis in that Yes,
It's not a question. Can I just correct something?
absolutely, Commissioner.
I suspect that you understood what I was saying when I said if you're unable to find, to give a full explanation why you did not prosecute certain people and others for gratification, that I meant to say it would suggest selective prosecution, decision
Understood
and
it.
investigation.
I
You
understood it that way.
Okay, thank you.
Thank,
Advocate Johnson, can I say this? Please keep it in mind for when you come back. My reading of Cracker is that gratification itself is not an offense. It is gratification in order to do something.
Or not
That
to
is the
do.
offense.
Yes,
Because gratification on its own, every time somebody gives you something, I mean, it's gratification, provided, of course, it falls within the definition. But it has to be linked to something that is going to be done, which is improper.
correct. And or something that is not going to be done in order to benefit.
But
the
there must
person.
be impropriety there. Because
Absolutely.
if something is being done as it should be done,
There's
then
no
it is lawful.
impropriety.
That can be an offense and people can be charged with that.
Absolutely.
thank you, Commissioners. Chair, it's obvious,
Yeah, I
we are
almost
not
said,
done.
when council said, until next time, I thought to myself, is next time not tomorrow? Sorry, we're all tired and one should have a light moment.
no, absolutely, no, nothing wrong in that. And I think I share in your hope, but it's just that, a hope. But the reality of the commission is, firstly, I've encroached on others' time. There's a standing program for Friday, so I doubt it will be Friday. But I think the best I can do is to request that Advocate Johnson's further testimony be stood down. As I understand it from the powers that be, I can't have Friday, I can't have tomorrow. It would be a question of to when. Thank you, Chair.
May we see council outside just now? We'll come back when we are ready to.
Chair,
Let's
thank you.
adjourn.
Thank you, Chair.